prayer for listing a lordship, a criminal appeal lordship, and upon
New,
10 years lordship, and
new.
no lordship, high is pending lordship.
Okay.
And prayer lordship and one criminal revision petition lordship, and there is only one dispute is there on the certificate lordship. Can it be lordship on Friday lordship?
Next week, next week.
May I please, your lordship? Lordship, may I mention a criminal appeal for hearing, my lord?
Hearing you make an application.
Obliged.
May I please, your lordship? I beg to mention item number 22, lordship.
Item number 22.
The
Yes.
Yes. Council M.U. Ahmed is out of station, lordship. This matter may be come up next week on 27, lordship.
Mr.
J.U. Ahmed, I'm.
J.U. Ahmed,
Yes, lordship.
learned counsel appearing for Mr. M.U. Ahmed, learned counsel for the petitioner has sought an adjournment. Post of Mr. R. Kosik, learned so and so is at who is in attendance, has submitted that the state has no objection to the prayer. Post of has prayed for release the case in the next week.
27.
I would like to mention one matter, my lord, for listing, my lord. This is a criminal revision petition, my lord. Earlier, it was mentioned but not listed, my lord. This is the second time, my lord. Only make it on Friday, my lord.
Not Friday, not this week.
The 25th.
Give it to the court master, he'll fix the date.
No, lord.
Please, I pray for listing a criminal petition for orders, my lordship.
Okay, give it to the court master.
With Jesus. For orders matter only. Me please. I beg to mention item number 15, my lord.
Item number 15
I on behalf of the SD Chaudhary, my lord, is unable to appear. before-
is indisposed.
Uh,
Okay,
Pass over for the people.
Mr.
Yeah, and I'm.
A.N. Ahmed, learned counsel appearing for Miss S.B. Chaudhary, learned counsel for the petitioners has submitted that Ahmed Chaudhary is indisposed and has thus prayed for listing of the case on another date. Post of Kosik Likidivo, Agonistan, has prayed for the list the case after 1 week. Okay, after 1 week. On a date to be fixed by the office.
May I please, lordship? I beg to mention for listing a anticipatory bill, my lord.
Anticipatory will not before this court.
My lord, actually, another for the same affair, another bill petition is filed. That is regular bill. That is fixed for CD 21/8.
No, not before this court. Bail is not to be mentioned before this court. Bails are not listed before this court, right?
May I please, your lord, so I beg to mention for listing for IA in criminal appeal, my lord.
Submit your mention memo.
Yes, lordship.
May I please, lordship? I beg to mention one criminal petition for listing, lordship.
Motion.
No, admission, lordship.
Okay.
Always.
Criminal appeal for orders, my lord, next week. Deep.
May it please your lordship. Lordship, item number 14, senior counsel, Mr. A.M. Bora would be appearing.
Oh, item number 14.
1-4, my lord.
Okay, raise the case before any other events without me.
Lordship, can it come up on 21st, my lord?
As the counsel for the petitioner. Petitioner has expressed urgency, the registry to list the case on an expeditious basis.
Obliged.
May I please, your lordship? I beg to mention a criminal petition, your lordship. It was last listed.
Or
Criminal petition for
admission.
Quashing. Admission, lordship.
Okay, give it to the court master.
Lordship.
May I please, your lordship? I beg to mention item number 32, lordship. It is a part-heard matter, lordship, but wrongly listed today, lordship, this honorable.
Okay, this is wrongly listed, sound 31.
32, lordship.
32.
Yes, lordship.
Mr. R. Ali.
M. Hussain on behalf of R. Ali.
Okay, R. Ali, the counsel for the petition has submitted that the case is a part-heard matter. As reflected in the order dated 15/7/2025. Mr. Nawaz is there. You are amicus. You are amicus perhaps. This is the matter showing the name of Mr. So-and-so. Okay. As ordered, as mentioned in the order dated 15/7/2025, the name of Mr. Sarfaraz Nawaz as amicus curiae is to be reflected, for the respondent number 2 is to be reflected in the call list. Office to list the case before the appropriate minutes.
Deeply obliged.
I beg to mention item number 5.
Item number 5.
I am going to file an additional affidavit. I'll fix the matter on Tuesday or Wednesday.
Okay. Mr. L. Gogoi, the counsel for the petitioners has submitted that an additional affidavit is going to be filed on behalf of the petitioner by tomorrow.
By tomorrow.
Okay, by tomorrow. He has just paid for listing of the case on another date. List the case on next Wednesday.
Obliged.
My lord, one pending matter, my lord, criminal revision petition, my lord.
Yes.
One pending matter, my lord, criminal revision petition, my lord. This petition is pending. It was last listed 7/11/22, my lord. So matter may come, my lord, on 22 because, my lord.
Give it to the court master.
May I please, your lordship? I beg to mention for item number 12, lordship.
12.
12.
Yes.
Due to personal incapacity, he is unable to attend the court, lordship.
Okay, on prayer, Mr.
R. Hawk.
R. Hawk, learned counsel appearing for the petitioners. The case is passed for the day.
Another prayer, lordship. I beg to mention for listing a criminal revision petition, lordship.
Hmm?
Criminal revision petition, lordship.
Okay, give it to court master.
May I please, your lordship, I beg to mention for criminal revision petition for listing,
For
hearing.
hearing, no.
May it please your lordship. Lordship, may I pray for listing of a hearing matter, my lord, 2019.
Hearing, you make an application before the listing.
May, my lord,
No.
my lord, if the mention is
A
allowed.
hearing list is prepared.
My lord, already 475 is listed in. the-
No, Mr. Doctor.
475.
May I please, your lordship? Lordship, I want to mention here criminal review petition, revision petition number 290/2024 for listing for orders.
Okay, give it to the court.
May I please, your lordship? Your lordship, I beg to mention for listing of a criminal petition, which was last listed on 28th of November 2020.
Okay, give it.
May please, your lordship. I beg to mention, I beg to mention a criminal petition which was last listed on 12/9/2024.
Okay, give it.
Please, your lordship, in item number 6, we have filed an additional affidavit yesterday, which is need to be called for on record, your lordship.
Okay.
For withdrawal, item 37.
Hmm? 90, HR surgery. Yes, account. মাতি দিব account মাতি দিব আছে দি ফোন নাম্বাৰ yes account নেকি অলপ পিছত মাতি
Daily list for motion, item 1.
May I please?
yes
My lord, impugn order, my lord, page 55, my lord.
page
Order, page
Yes.
55. Next at 10, order dated, my lord, 25/7/2025, my lord. By which, my lord,
petitioner is present, witness is
by order dated 25/7/2025, my lord. My lord, the petitioner is, my lord, the cross-examination part of the petitioner has been closed, my lord.
hmm.
My lord, I appease before this one, the salary fees. are-
What is the petition? What is the stage of the proceeding?
My lord, cross-examination part has been closed, my lord, and now fixed, my lord, for evidence of petitioner. My lord, without cross-examination of the PWs, my lord, I will be prejudiced, my lord. So, my lord, one chance may be given, my lord, to cross.
He is present,
examine the
submitted his
PW.
written statement, short time to submit his affidavit of disclosure of asset by the opposite party. Absent. Allowed as a last chance, subject to deposit of ransom. Aforesaid cost on being deposited be given to the petitioner. 7/4. On H7, it was given, you were given last chance.
Yes, my lord, that is true, my lord. but
Then
8/7 was,
Then-
my lord.
25/7, how is the 25/7 order?
My lord, on page
25,
55, page
20
50. Below portion, my lord.
25,
Page 50, below portion. On that day, my lord, I was present, my lord.
Opposite
The
party
learned King's
present.
counsel, my lord, expressed inability to, my lord, conduct the case. That is why, my lord, the cross-examination of the PWC. was-
So on what ground? Mercy ground?
My lord, since
Because now
I-
BNSS does not.
I was present, my lord, but my lord, learned King's counsel, my lord.
Now what
expressed
is,
inability.
what is 436 says? No, BNSS. What is the provision? I think 436 new. 436 or which is the provision for adjournment? That day. Which was, is the provision for adjournment? Yes, please, public prosecutor. 346.
Adjourned. Two D.
My lord, 346D, my lord.
Two D.
Yes, 2D.
2D.
Can dispense with cross-examination.
My,
Law is against you.
Mm.
Procedural law is against you.
Mm.
Is it not?
my. So only
So-
one chance may be given, my lord.
How many last ones? All are already last ones recorded.
No, my lord, I have FIR and my lord file petition, my lord. which
File
is not-
petition, that ground is not. You are what? Because we will be exercising our inherent powers. Subject, because your conduct is also not
My
good.
lord, in a similar. case, my
You,
lord,
no, will not see similar. We will only impose cost. Because so that it has a deterrent effect. So that in future, you will abide by the provisions of law. You are an employee of what?
My lord, constable of forest.
Yes,
My lord,
Mr. Sharma, what do you say? Cost.
Cost.
What should be the
Will it
reasonable,
cost?
at the same time deterrent,
Yes, my lord.
so that he does not do so
Yes.
in future?
Around my lord 2000.
Only 2,000.
Because he said he's constant.
I was thinking of 10,000.
My lord.
It should have deterrent effect and should not be also beyond his capacity.
My lord. My lord.
That is why I asked what is his nature of employment.
My lord.
5,000.
My lord. Right.
Hard. Mr.
Yes.
A. Hussain, learned counsel for the petitioner, and Mr. B. Sharma, learned additional public prosecutor for the respondent number 2, State of Assam, post of. Having regard to the issue involved, the case is taken up for consideration at the motion stage itself, dispensing with the procedure of issuance of notice to the respondent number 1, post of para. The instant criminal petition and the criminal revision petition under section 438 and section 442, paired with section 528 of the BNSS is preferred by the petitioner, agreed by an order dated 25/7/2025. This should have been under section 19(4). I am saying time and again, why don't you read the law? Agreed by an order dated 25/7/2025. Passed by the Court of Learned Principal Judge, Family Court at Dhuri, within bracket, the Family Court for short, full stop. The respondent number 1 hearing claiming to be the wife of the petitioner has instituted has filed a petition under section 144B and SS before the family court claiming monthly maintenance from the petitioner. First up, the said application has been registered and numbered as FC Miss within bracket criminal case number 03/2025, wherein the petitioner is the sole opposite party. Full stop. Notice was issued after registration of Miss case number so and so. No, FC criminal case number so and so. Notice to be issued to the petitioner for his appearance and filing of written statement. Full stop. On receipt of notice, the petitioner appeared before the family court and in due course submitted his written statement. Full stop. Though a number of opportunities were granted to the petitioner to submit his affidavit of disclosure of assets and liabilities, the petitioner failed to do so. Full stop. Para. In the course of the proceedings, the petitioner shorn of unnecessary, SHORN, shorn of unnecessary details. It can be stated that the petitioner submitted her examination in chief on affidavit along with two other witnesses, namely S.K. Ghulam Mustafa, page 49, within bracket PW2, and Zahirul Islam, within bracket PW3, on 18/6/2025. Full stop. On that day, the petitioner was absent by filing a petition, petition number 65/2025, seeking time for his appearance. Full stop. The family court posted a case on 8/7/2025 next for cross-examination of the petitioner's witnesses, if any. Full stop. On 8/7/2025, the petitioner as PW1 was present with the other two witnesses, PW2 and PW3. Full stop. But on 8/7/2025 2 TWO, the petitioner was found absent. Full stop. However, a petition, petition number 75/2025 was filed on his behalf, seeking adjournment, showing the cause, seeking adjournment on the ground that the day he had to, on that day he had to join at his new place of posting. Full stop. Considering the ground shown in petition number 75/2025, The prayer made on behalf of the petitioner was allowed as a last chance by imposing a cost of rupees 1,000. Full stop. The Learned Family Court posted the case on 25/7/2025 next for cross-examination of the petitioners R.O.P.S. witnesses, PW1, PW2, and PW3. Full stop. Para. On 25/7/2025, the petitioner as PW1 along with PW2 and PW3 who was present before the Learned Family Court to face cross-examination. Full stop. The petitioner was present on that day, but he filed a petition number 78/2025, seeking adjournment. Full stop. In petition number 75/2025, the petitioner stated that he received the copies of the evidence of the PWs and also deposited the cost imposed on him by order dated 8/7/2025. Full stop. Here, however, prayed for another date for cross-examining the PWs on the ground that his engaged counsel, it was not possible for his, due to inability on the part of his engaged counsel to cross-examine the witnesses. Full stop. Para. The Learned Family Court observed that last opportunity to cross-examine was already granted earlier, and hence, petition number 75/8/2025 lacked merit due to absence of any plausible cause for adjournment. Full stop. The only grounds the court noted that the Learned Family Court noted that the only grounds shown has noted that only grounds shown is that the learned engaged counsel is not able to conduct the case. Full stop. Observing so the cross-examination of the petitioner's witnesses you did not deposit the cost also. Learned Family Court has decided to close the cross-examination of the petitioner's witnesses. Full stop. The Learned Family Court has also observed that observed that it has been reported that the cost imposed on 8/7/2025 has not been deposited by the petitioner. Full stop. The Family Court has proceeded to fix the case on 19/8/2025 for evidence of the opposite party witnesses, if any. Full stop. Para. Agree by and dissatisfied with the closure of the opportunity to cross-examine the petitioner's witnesses. The petitioner has approached this court by the instant criminal revision petition. Full stop. Provisions. Now, as per no, the power to postpone or adjourn proceedings. Has been provided in section 346 B and SS. Full stop. As per the proviso, second proviso to subsection 2 of section 346. As per the second proviso to subsection 2 of section 246 BNSS has provided that when witnesses are in attendance, no adjournment or postponement shall be granted, without examining them, except for special reasons to be recorded in writing. Full stop. Clause A of the fourth proviso has stipulated that no adjournment shall be granted at the request of a party, except where the circumstances are beyond the control of that party. The fourth proviso has to subsection 2 of section 346 PNSS are read as under ABCD. Explanation 1 and 2 likhbo. When from a plain reading of the order dated 25/7/2025, it does not emerge that the family court has proceeded in a manner contrary to the procedure laid down in section 346 BNSS. Full stop. It can, at the same time, it can be noticed that on 25/7/2025, the petitioner was present in person, and it is the learned English counsel who did not conduct the cross-examination. Full stop. As a result of the order of the learned family court dispensing with the cross-examination of petitioners' witnesses, the petitioner has lost a vital opportunity for establishing his case it is one of the contentions raised by the petitioner is that there was no marriage solemnized between the petitioner and respondent number 1, as claimed by the respondent number 1 in her application under section 144 BNSS. Full stop. Explanation 2 to section 346 BNSS has provided for terms on which an adjournment or postponement may be granted, and in an appropriate case, the payment of cost by the prosecution or the accused can be ordered. Full stop. Having regard to full stop, considering the or so if cross-examination, if one further opportunity is granted to the petitioner herein to cross-examine the PWs, that is PW 1, 2, and 3, is not going to be detrimental in comparison, is not going to be that detrimental in comparison to the possible detrimental effect going to be caused to the petitioner if he is not allowed to cross-examine the prosecution witnesses. At the same time, it cannot be any adjournment or postponement cannot be allowed except for special reasons. Even the any cost imposed, any order to make payment of cost while granting adjournment or postponement is to be made keeping in view that the same shall have the same shall have deterrent effect to the party to seek any further adjournment or postponement. Yet at the same time, a payment of cost should not be such. The amount of the cost imposed should not be such that it is beyond the capacity of the party to pay deposit. Having considered the pros and cons, having considered the matter from the balancing the interest of the parties, this court is of the considered view that the petitioner can be granted one further opportunity, as a last one, to cross-examine the witnesses, prosecution witnesses, PW 1, 2, and 3 by setting aside that part of the order dated 25/7/2025, whereby the Learned Family Court has closed the opportunity of cross-examination of the prosecution witnesses PW 1, 2, and 3 to the petitioner. Full stop. It is accordingly ordered. Full stop. When is the next date?
My lord, 2 days next.
No, I know. Then when will be the next date? I don't know. The petitioner will appear before the Learned Family Court in person, along with his Learned Engaged Counsel, on the next date of hearing of the case, along with a copy of this order, so as to enable the Learned Family Court to fix a date for cross-examination of the prosecution witnesses PW 1, 2, and 3. By putting the other side on notice, first of, with the observations made and the directions given above. This criminal petition, revision petition is disposed of in the appropriate terms. No cost. Oh, we did, it was a copy of the order and deposit of rupees 5,000.
My lord, 2 days is fixed. Today, my lord, today may cast another order. My lord, that order may be also it.
Huh?
2 days fixed before the honorable tribunal, honorable family court.
You inform the family court, the court has passed this order. File a petition there.
Obviously.
Item number 2.
May I please, Your Lordship? 483 petition.
We can only issue notice here.
It has to be heard.
But that is the law now.
Yes, accused has to be heard.
Hmm?
Accused has to be heard, yeah. That's one.
The petitioner has no right to be heard at that time if the ground of arrest is faulty.
I annexed the memo, Your Lordship.
Huh?
Notice number 47, 48 is there.
Nowadays, that is a happening thing.
There is some dispute regarding how much to be retained.
I don't know. I have not read that.
Yes,
Heard Mr. R. Mazumdar, Learned Counsel for the petition, and Mr. R. Kosik, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, post of agreed by
Next, read order date.
an order dated 13/7/2025.
Oh, Your Lordship, 29, sir. Last-
Agreed by an order.
29,
But
sir.
you are challenging both.
Bail order is 13/7
Huh.
and
Huh.
rejection order.
Agreed
is-
by an order dated 13/7/2025. Passed by the court of and another order dated 29/7/2025. Within bracket Atta Annexer 5, Atta Annexer 8. Passed by the
Judicial magistrate.
Court of Learned Judicial Magistrate First Class Nagaon, Assam Trial Court. In connection with Jajuri Police Station case number 48/2025, the petition has referred the instant criminal revision petition. Issue notice returnable in 4 weeks. Or returnable on so and so date. as Mr. Kosik, one, the petition shall take steps for service of notice from the response number 2 by registered post with AD as well as by usual process within 3 working days from today.
17-9. Item 3.
May I please? Lordship, petitioner before your lordship.
Chief Judicial Magistrate Judgment NIA case.
Lordship.
Yes, what is the conviction?
Lordship 6 months. And
6 months,
lordship in default.
280,000.
Lordship.
Then criminal appeal,
Lordship, this is the.
Confirmed. affirmed,
Lordship.
affirmed.
Affirmed.
You are in revision.
Lordship.
So
So Lordship,
280,000,
Lordship, that is,
56,000.
Lordship, but it is true, Lordship, but our case is that I was the salesman of the complainant. Firm. That is also.
You have
admitted
failed
by-
on before 2 forum.
Lordship,
We are not entering into that.
Lordship, I'm.
You deposit or not deposit?
Lordship, I take your.
You
Lordship,
contest the case in custody.
this month, Lordship, at this stage, Lordship, otherwise, I take your Lordship to.
280,
evidence.
20%
Cross part
of-
the Lordship, cross part. of the complaint.
20% of 280,000. What is the amount?
Okay. Yes,
56,000. Deposit. What is the period, Mr.? 60 days.
Lordship, can it be 40?
We can increase
40, Lordship. 40.
that decision,
That
that
decision,
discussion is not available. Either it is 0 or it is 20.
But Lordship,
Then 25%. This is not a market.
Lord-
We go by the provisions of law. That's all. Heard Mr. L.R. Mazumdar, Land Council for the petitioner, a revision petitioner, and Mr. R. Kosik, Land additional public prosecutor for the response number 1, State of Assam, post of the petitioner faced criminal proceedings in NI case number 149 of 2022 as an accused. Proceedings before the Court of Lands Chief Judicial Magistrate Kachar Silsor Trial Court as an accused for an offence under Section 138 Negotiable Instrument Act 1881 as amended NI Act, wherein the response number 2 was the complainant, post of the Learned Trial Court convicted the finding the petitioner accused guilty of the offence under Section 138 NI Act, convicted him, convicted and sentenced him to pay a fine of rupees 280,000 in default of payment of fine amount, to undergo simple imprisonment for a period of 6 months, post stop. When the petitioner preferred an appeal before the Court of Lands Additional Session Judge number 3, Kachar Silsor Appellate Court, in criminal appeal number 36 of 2024, the Appellate Court, by its judgment dated 25/6/2025, has confirmed, has affirmed the conviction, judgment and order of dated so and so of the of conviction and sentence passed by the trial court. Hence, the present criminal revision petition. The criminal revision petition issue notice returnable in 4 weeks. As Mr. Kosik, response number 1, take steps, response number 2, raise that post as well as the usual process. Hard dull on it. counsel for the parties on the interim prayer regarding suspension of the execution of the sentence passed against the revision petitioner. In the light of the provisions contained in section 148 of the Negotiable Instrument Act. Post of the no exception case, the learned counsel for the revision petitioner. No, sorry, the revision petitioner has not been able to make out an exceptional case. To extricate him out of the rigors of section 148 Act. Post of having regard to the nature of the disputes involved, it is ordered, in the interim, that the execution of the sentence passed against the revision petitioner shall remain suspended, subject to deposit of 20% of the fine amount imposed. That is 20%, 20% of the fine amount imposed, 2,80,000. That is 56,000. Before the registry of this court within a period of 60 days from today.
Like item 4.
Please, your lordship.
The joint petition, my lord, filed by the accused and the victim, case under Child Marriage Act and my lord Foxo Act.
We will issue notice at this.
Lordship protest.
1 minute, 1 minute.
How
many petitioners? 4. Okay. What happened initially?
Initially, Lordship,
FIR was filed.
FIR was filed, Lord.
Where is the FIR?
FIR, Lordship, at page 33, Lordship, type copy, Lordship.
Page 16 or what?
33, Lordship.
33. Okay. Then
Lordship,
final report.
page 36 is the final report, Lordship.
Thereafter,
that informant filed the Lordship complaint case, Lordship. Page 39.
complaint case.
Complaint. On 19/7/2024.
And cognizance.
Cognizance was taken, Lordship, page 48, Lordship, 10/6/2025.
What does your affidavit says?
Lordship, I have filed my affidavit, Lordship.
Hmm.
Paragraph 5 and 6 is relevant, Lordship. Paragraph 5 and 6, Lordship.
Yes.
Here, last occasion, your lordship has pointed out this section 223, my lord. Now my learned friend has-
Investigation was done.
Yes, my lord.
Final report submitted. They were not succeeded. Again complained. So this time at least. Because some kind of right has accrued to them.
Yes.
There was no perhaps protest petition. We don't know.
We don't know, my lord. Only thing is that because otherwise it's a complaint petition, but last occasion your lordship was having that at this section 223, my lord. That's why my learned friend has filed
He
this.
is asserted now.
Asserted now.
We'll state a
That was
person.
not followed. The only thing
You've
is that
not
my lord.
followed. The only thing is that earlier 205 there was one provision.
Yes,
It's just set aside and again remand back the matter.
yes. Now
So this
new
will happen
edition is
again.
there. Now new
This
edition.
kind
is
of
there.
petition will start coming.
Yes, ma'am.
In fact, it has started coming.
Yes.
Third, Mr.
NH Morgan.
N.H. Borbhunian Learned
And the
Counsel for
only
the
thing is that
petitions.
because otherwise we are only formal party. So
Ah.
we did that.
Anyway, you are there or not?
Yes.
Complaint
We
is
are here.
number 2, Lord.
But you assist the court.
Yes, sir. No, we are assisting on only thing that whether this
R.R. Kosik Learned Additional Public Prosecutor for the Adjustment number 1, state was sound. Post of the petitioner are aggrieved by an order dated 10/6/2025 passed by the Court of Learned Subdivisional Judicial Magistrate M. Majuli, Trial Court. Post of by the order dated 10/6/2025, comma, the Learned Trial Court taking cognizance of on a complaint, comma, registered as CR case number 23/2024, comma, for the offense under section 420 Indian Penal Code, read with section 34 IPC, has ordered for issuance of summons to the petitioners for their appearance before the said court to answer the charge. Full stop. Para, it is contended that on behalf of the petitioners that earlier an FIR was lodged by the same
Yes, sir.
informant,
Thank you.
that is the respondent number 2, and the said FIR was registered as Majuri Police Station or Goramur Police Station, right?
Yes, ma'am.
Case number 66/2023, and was investigated into. After investigation, comma, the IO of the case submitted a final report stating that the petitioners could not be charge sheeted. Post of. It was after submission of the said final report on 15/12/2023. The respondent number 2, the respondent number 2 as the complainant has instituted the complaint case, comma, CR case number 23/2024. Post of. The submission in advance on behalf of the petitioners that before issuance of process by the order dated 10/6/2023, comma, the Learned Trial Court did not adhere to the procedure laid down in the proviso to subsection 1 of section 223 of the B&SS. So issue notice returnable on so and so as Mr. Kosik, respondent number 1. The petitioner shall take steps for service of notice on the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today. Having regard to the from the contents of the order dated 10/6/2025, comma, it does not emerge that the provisions laid down in the proviso to subsection 1 of section 223 or the BNSS has been complied with. Post of. Having regard to the provisions, post of, it is therefore ordered, comma, in the interim that further proceedings of CR case number so and so pending before the so and so shall remain suspended till the returnable date.
19/9.
Item 7.
May I please your lordship? Next,
Yes, sir.
page 26, we are challenging the order of the executive magistrate of attaching.
Yes, firstly, page 26, the case is dropped.
Yeah, but your
Right.
lordship, just before that,
Huh?
further the concerned police station.
One more part, whatever disputed land, the status quo was ordered already by the civil court,
Yes.
right?
Stated
Only
by
thing
the-
that concerned police station may be instructed to attach the DL.
The
That part cannot survive if the case is dropped, cannot survive.
But they are not allowing me to enter my own.
No, we say that because page 26, if that executive magistrate has dropped the case,
Yes.
any order
You must-
passed
that's
cannot survive.
True, your lordship is right, but now the police are not allowing me to enter.
We
my
don't know. We'll simply this part cannot survive. This direction to attach the DL cannot survive. In view of the in view that the same authority has dropped the proceeding.
Hmm.
On the other hand, there is an order of the civil court already. Where is that order?
The order
Of
is that-
status quo.
Yeah. Page
That will
one-
continue.
Page 138 and 39.
130.
9. It is in my favor.
We don't know about whose favor. It is, we don't know. Equally lies. We don't know. Civil court has said, sir. Let us see 139. This court, in consideration of the observation made in foregoing paragraph point, found that passing any restraint order against the OPs will surely cause irreparable loss to them, as the balance of convenience equally lies
Yes.
in their favor, similar to that of the petitioners. In respect of the suit schedule A and E, what is involved in this impugn order?
E.
E.
E is.
So this is the observation. Thus, it is found that the learned trial court was not proper in deciding the balance of convenience irreparable loss and solely in favor of the petitioner. According, the injunction order is set aside. So this part is material, right?
Yeah. Kindly
Equally lies. We are not going into that. You fight it out. But this part drop, this attachment is not proper. We'll observe on that.
Yes, you.
That's all.
Yes. We will.
Yes. Heard. Mr. D.K. Agarwal, learned counsel for the petitioners, and Mr. R.R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam. So stop. Para, the instant criminal petition under section 528 of the Bharatiya Nagorik Surakha Honita 2023 is preferred, seeking quashing of an order dated 10/7/2025 passed by an executive magistrate Golaghat in Miss case number 44/2024. Full stop. Now we have to issue notice then, otherwise again something will crop up.
Say the.
The proceedings of Miss case number so and so has been instituted by the respondent number 2 and 3 as first party before the executive magistrate Golaghat. And the petitioner's hearing or the are implemented as the second party. Full stop. Para, it has been pointed out that the respondent number 2 and 3 as plaintiffs and the petitioners as defendants are involved in a civil suit, title suit number 24 of 2023, presently pending before the Court of Learned
Munsif number.
where
Kolaghat.
Learned Munsif Golaghat
Senior,
post op in a proceeding initiated under Order 39, Rule 1 and 2, which finally ended in appeals before the Court of
civil judge. Senior.
Civil Judge Senior Division within brackets, Golaghat, in the form of Miss Appeal number 01/2024, comma, within bracket appellate court, the appellate court, by an order dated 8/4/2025. Dispose of the appeal with the following observations and directions. Page 139. Red mark 2. Red mark. Post of. Para. The impugn order. Dated 10/7/2025. Reads as under. Page 26. Order of drop from the court. From a plain reading of the impugn order, the issue notice returnable in 4 weeks. Co-6, 1, 2 and 3, registered post, usual process. From a plain reading of the impugn order dated 10/7/2025, comma, it can be noticed that the executive magistrate Golaghat has already dropped the proceedings in view of the pendency of the title suit before the civil court. Full stop. From the operative part of the order dated 8/4/2025, passed in Miss Appeal number 01/2025. An order of status quo with regard to the schedule lengths, that is Schedule A and Schedule E, are in operation as on date. Full stop. According to petitioners, the disputed land involved in our impugn order dated 10/7/2025 is Schedule E. Full stop. Para. Oh, no, like para, no. As already an order of status quo is in operation by virtue of the order dated 8/4/2025 passed in Miss Appeal number so and so, comma. The observation made, the direction, sorry, the instruction made in the impugn order dated 10/7/2025 to the effect that the police station shall attach the disputed land is found primacy not in conformity with the order of status quo passed by the land civil court. And in such view of the matter, comma, that part of the impugn order dated 10/7/2025 instructing attachment of the disputed land is ordered to be kept in abeyance.
That's much obligation. Item number 8.
Yes.
This criminal petition is filed for quashing of a PRC case, Your Lordship, presently which is pending before the Honorable Court of the Chief Judicial Magistrate, Kamrup Metro. Actually, this matter is arose, Your Lordship, due to
Where is the FIR?
Pardon, Your Lordship?
Where is the FIR?
Yes, case number 14, Your Lordship. This FIR was filed by the petitioner number 1 against the petitioner number.
Let me read.
Yes, Your Lordship.
Who are the petitioners?
Husband and wife, Your Lordship. Presently, they have already divorced.
To inform you that. Yes, Mr. Kosik.
This is a marital dispute, Your Lordship.
Right. Yeah, yes.
Item 9.
May I please, Your Lordship?
Yes.
Lordship, this is application under section 528 BNSS, my lord. We are praying for quashing of FIR, my lord. Offense under section 316(2), which deals with the, my lord, criminal breach of trust, and 318 subsection 2 and 3, which deals with the criminal
Cheating.
conspiracy, my lord. Cheating, yes.
Both the accused persons introduce
my lord.
themselves
And page
as
11 is the
PWD contractor. Accused one since June had taken 40 lakhs in 3 installments from me. On the petition provide subcontract. On 15/8/2019, taken total 13 lakhs. Signing receipt on this paid, but the said accused did not give any work. As such, I demanded return money. Then the, in lieu of return of money, issued his central bank account bearing the and so and amount 35. Then both the checks bounced. No money. But I repeatedly went to the house. Yes, any institution of NI case?
Yes, my lord.
Huh?
He has the alternative remedy before.
No,
under-
did he institute?
That is the information.
Heart, Mr.
Azar.
A.K. Azar Learned Counsel for the petitioner. And Mr. M.P. Gulsami and additional public prosecutor for the respondent state. Post of the instant criminal petition under section 528B NSS is preferred seeking passing of a first information report registered as
Bodorpur PS case number
Bodorpur Police Station, case number
31/22.
31/2025, registered for offences under sections 62 within bracket 1, 316 within bracket 2, 318 within bracket 2, stroke 318 within bracket 3 of the Bharatiya Nagorik Parikha Honita, sorry, Bharatiya Nyaya Honita, BNS 2023. And the consequential proceedings of GR case number 269/2025. First of it is contended that the ingredients from a plain reading of the FIR, the ingredients of the offenses alleged are not met out. Issue notice returnable in 4 weeks. Returnable on so and so.
17-9.
The petitioner shall take steps. Petitioner, one petitioner or how many?
One petition.
Petition, okay, as Mr. Goswami. One, and steps raised at post usual process upon response number 2 by raised within 3 working days. The additional public prosecutor shall obtain a status report of investigation of so and so case number to place the same on the returnable date. The prayer for interim relief is kept open for consideration on the returnable date.
Further proceeding will be, I'm praying for interim for stay order.
On the returnable date.
No, because first part, my lord, it is.
We'll see that
Possible.
everything is not ready-made.
No.
Item 10. May it please your lordship.
Yes.
Lordship, this is a matter of attempt to rape lordship and
Hmm?
washing lordship.
Washing.
Lordship.
Why? Why is the FIR?
FIR in page 12 lordship.
FIR is in page 12.
May I read lordship? On
And where is the lady? Yes, she is as per number 2.
number 2 is the informant lordship. Or
She is as per number 2.
this one,
Vasudev.
Vasudev.
Vasudev is the complainant.
Complainant lordship.
He is the husband.
He is the husband lordship of the
Then let him come. Any settlement?
settlement was there lordship.
Where is that?
AB is lordship as per AB order in page number 15.
Oh, AB order is not. AB order cannot be. That is a tentative.
One is there as per the CD.
That is a
lordship.
tentative thing, sir. And it is the offense is related to the person of a lady. Will issue notice.
Lordship.
Heart, Mr.
Yes, Hussain.
S. Islam
Yes, Hussain.
Hussain, learned counsel for the petitioner, Mr. MP Goswami. Response number 1. The present criminal petition under section 528 BNSS is preferred seeking quashing of an FIR first information report registered as Ajo Police Station case number 464/2024 under sections 329 within bracket 4, 64, 62 of the Bharatiya Nyaya Honita 2023 and the subsequent charge sheets submitted. Issue notice returnable. It is stated that it is submitted that the parties have amicably resolved the dispute. Post issue notice returnable on so and so date.
17-9.
Goswami, response number 1. Extra copy, 3 days. Response number 2, raised at post usual process within 3 days. The same status report investigation. Interim prayer on the returnable date.
Yes.
Obviously. Item 11.
Yes.
May I please your lordship? It is an application of 428 of the BNSS. My lord, what happened, my lord? I am a student as well as a truck was also purchased in my name by my father, my lord. And which has been handed over to our driver to to carry the business, my lord. Then, my lord, on the date of the occurrence, my lord, this truck was carrying on 11/5/23
number of Burmese block from Mizoram to Assam. And my lord, there was a signal by the police to stop it. The driver did not stop. He rushed, and in the midst of the road, he fled away out of fear, keeping the truck in the dark place.
Keeping?
Keeping the truck in the dark place.
Ah,
Then my lord, police came to that spot and found the bullock as well as the truck. So they have brought them to the police station. And my lord, thereafter, the truck owner has appeared before the court. That is this.
truck owner means you?
Yes.
Huh,
And we have prayed for the Jimma
huh.
of the vehicle and also prayed for the anticipated rebate. Court has granted that too also. The vehicle has been given Jimma. Then in the meantime, the owner of the bullock,
Huh.
he has appeared before the court and filed an application for the Jimma of the bullock by producing the challan that I have purchased it from Mizoram such and such person. So court on being satisfied given Jimma to the bullock owner also. Now, my lord, after this charge sheet is filed against me,
Only against you?
only against me. That's why, and I am in no way connected. And the bona fide purchase, the bullock owner has taken the bullock, that indicates that bullock belongs to him.
No, that is indicative, not establishing.
Yes, but he ought to have been made accused, my lord. Now, I take
Okay,
your
we'll examine, then we'll call for the scan copy of the case record.
exactly, my lord, kindly.
We'll examine the materials. If it is not so, then definitely we'll interfere. Where is the charge sheet?
Charge sheet is at page
Okay. Heard Mr. S.C. Biswas,
charge sheet is page
learned counsel for the
21, my lord,
petitioner. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent state. Seeking Quashing and setting aside of the proceedings of police report case within bracket PRC number 4172 2024, comma corresponding to Dwarmont police station case number 56/2023 under section 379/411 Indian Penal Code,
Read
read
it,
with
13
section
of the Assam
13(1)
Cattle
of the Assam Cattle Preservation Act, comma 2021, comma the present petition under section 528B and SS is prepared. Issue notice returnable and 4 weeks. The as Mr. Goswami has appeared, accepted. Scan copy of the case records of PRC number 4172/2024 be called for register judicial. The prayer for interim relief is kept open for consideration the returnable date. Yes,
My lord, may I pray to further proceeding till that.
we'll examine the scan copy. Have you received summons?
Yes, madam.
Yes, that's, I have also prayed time also.
There is nothing to be afraid of. You appear?
I have already appeared.
Okay. We'll see that data returnable date.
15/9. Item 13. Item 13.
But I pay for the possible matter.
No, I am dismissing it.
No, may not, my lord. There is a material.
No,
to be
no.
considered, my lord.
How
But
can in a 528 sit up here? I'm outrightly dismissing it without hearing you.
My lord, 528, I have been quashing the.
No.
Five-
See up here.
428, only.
Page 6. Page 6. Without giving any chance, I'm dismissing it.
My lord, number, section is wrong. my
I'm
lord.
dismissing it.
Section is wrong. My lord.
No, section is not, prayer is wrong.
Well, prayer is, we have made that. Grant a
Calling
prayer.
upon the respondent to show cause as to why the petitioner shall not be enlarged on bail in connection with PR case number so and so.
Yes.
And after perusal of the record and causes shown, if any, and after hearing the parties, pleased to grant bail to the petitioner in a 302 case,
Yes.
right?
Yes.
You are filing criminal petition.
My lord, your lordship has got the power to.
No.
Give me the liberty, my lord. Would
You file anticipatory bail application if you want. But this is not the way.
Here, the charge sheet has been filed. That's why I've come.
Search it even if that law is not that.
Of course, charge sheet case also your lordship can grant.
Yes. No, in not under.
No, no,
528.
not under this section.
Yes. It has to be. It has to be with a separate nomenclature,
Very true.
invoking separate provisions. We do not want to mix up.
Allowed to withdraw money with the
Yes.
liberty.
Appropriate remedy. Heard Mr. C. Biswas, Learned Counsel for the petition, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state. Mr. Biswas, Learned Counsel for the petition, has submitted that in view of the prayer, he may be allowed, the petition may be allowed to withdraw the petition, withdraw the criminal petition, referred under section 528B and SS in order to avail appropriate remedy. In view of the above submission made by Mr. Biswas, Learned Counsel for the petition, the criminal petition is dismissed on withdrawal, with the liberty as paid for.
Item number 16.
May I please?
Yes,
My lord, a quashing petition, my lord, for quashing of an FIR, my lord.
yes.
My lord, what has happened, my lord, the petitioner before my lordship, my lord, is a practicing advocate at the Morigaon bar, my lord. Now, my lord, allegation is that my brother is, my lord, somehow connected with, my lord, cybercrime fraudster. So therefore, my lord, an allegation that my brother, I was helping him in hiding in my residence. And so therefore, my lord, the police made a search at around 2:30 AM in the night, my lord. And that, my lord, period, and when, my lord, I wanted to know the reason, my lord, they started beating me in a very, my lord, barbaric manner. Now, my lord, for that, I have already lost complaints after complaint before the police also, as well as before the superintendent of police also. But both the authority, my lord, has declined to entertain that. Then I approached before the learned court below, my lord, filed a CR case, my lord, complaint petition. Now, I beg to draw my lordship's attention to that.
Has it been registered?
Yes, my lord, the CR has been ultimately registered, and next date for appearance is on 24/9/2025, my lord, next date.
Cognizance taken.
My lord, yes, my lord.
Cognizance taken.
Yes, my lord, from the online case status report, my lord, we have checked it. So it as the matter has been shown for appearance, my lord. Okay. That, my lord,
Okay.
cognizance taken. Now, my lord, the FIR, what the police has done, subsequently to my FIR, my lord, a counterblast FIR had been lodged. My lordship may be pleased to find that FIR, my lord, is at page 22, my lord. Which I am praying before my lordship for interference, my lord, at page 22, my lord. Page 22, my lord. May I read, my lord?
Do you have any acknowledgement regarding your filing the petition before the
My
SP
lord, acknowledgement, I
on
do not.
5/6/2025?
My lord, the online case record has shows, my lord, we have just verified and checked it up. But it has been numbered and the next date has been shown as.
No, page 29, you have annexed something
Oh, my lord,
that you have submitted an FIR before the SP.
my lord, that.
Right, obviously, because if the
Yes.
Lahorighat police station is inimical to you, definitely you would file.
No, no,
Were there any
there-
acknowledgement from the SP
No,
office?
my lord, there is no acknowledgement in the vernacular, my lord, which we have submitted, my lord.
Ah.
It has not been shown any any seal sign and signature is not here, my lord.
Okay, Mr. Goswami,
Lordship.
get a status report of
Yes, my
investigation.
lordship will find
of Lahorighat Police Station, case number 125 of 2025.
Yes. 178,
Page, page 25, 26.
page 22. Yeah,
Ah.
25 is the, my lord.
This is
type-
taking crossing of it, he has preferred the petition.
Yes.
Had Mr. A.R. Bullion, learned counsel for the petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam, post of seeking quashing of a first information report registered as Lahorighat Police Station, case number 125/2025, registered under sections 61 within bracket 2, 109 stroke 126 within bracket 2 stroke 132 comma BNS on 5/6/2025. The petitioner has approached this court by the instant petition preferred under section 528 BNSS post of para. It is contended on behalf of the petitioner that in respect of an incident, comma, there was in respect to the same incident, comma, the petitioner had earlier approached the had made approach, lodge an affair before the police station. As the said affair was not accepted, comma, the petitioner approached this Superintendent of Police Morigao on 5/6/2025. Post of. What happened? Not accepted or what?
No,
What
no,
is
no,
your
no.
contention?
My contention will not accepted by the SP.
As the said affair was not accepted by the office of the Superintendent of Police Morigao, the petitioner has to approach the court for
Right.
filing of a complaint, which, comma, he did. Post of the complaint has been registered as CR case number 448/2025. And the Land Court has already taken cognizance and issued process against the respondent number 2,
Right.
there's informant, or
Whether
respondent number
copy-
2, comma, who is the informant in Lahorighat Police Station, case number 125/2025, post of para. It is further contended that the affair in Lahorighat Police Station, case number 125/2025, has been lodged by the respondent number 2 as the informant, giving a different projection than the actual incident.
Mile.
Post of issue notice returnable on so and so date.
Yeah.
As Mr. Goswami for 1, a petitioner shall take steps for respondent number 2, by so and so and so and so within 3 working days. Then the preliminary edition public prosecutor shall obtain you get a scan copy of the case diary?
Yes, a scan copy can be gone.
Scan copy of the case diary for perusal of this court on the returnable date. Returnable date decision, the prayer for interim relief is kept open for consideration on the returnable date.
Yes.
No coercive action may be.
Niharika.
Yes. Because they are specific.
Mile.
And another one submission, my lord, regarding this complaint case, my lord, perhaps we don't know whether cognizance taken or not, my lord.
He has stated.
Yes, per his statement.
Yes, contended, I have said.
Lord, yes, that is,
I have verified from the online portal system.
Get the information up to date. On the next day you place.
Mile.
If it is registered, cognizance
Yes,
taken, proceeding started. Right?
Obliged. Highly obliged.
Item number 17.
Yes, sir.
Lordship, in this case, Lordship, I am challenging the order that is on page 34, Lordship, rejecting the GIMA of the vehicle, Lordship. I am the owner of the vehicle, Lordship.
Owner of the vehicle, what kind of offense?
Lordship, NDPS case 21B and 29, Lordship. Driver was arrested, Lordship. He is not my driver, he is actually friend of this petition.
Whatever. Or KBT. KBT was there or not?
Yes.
KBT is there. In your vehicle?
My vehicle, Lordship.
Huh?
I was not there, Lordship.
No, KBT was there or not? Specially made chamber is available or not?
Not lordship, it's not.
Let us have a look. I have
Because
asked you,
Because there is a, from the bag,
what is the vehicle?
lordship, it's a Hyundai vehicle, lordship.
Hyundai Venue.
Yes, lordship.
Your name is
My name is lordship Safaruddin.
Faruddin. Where is the impugn order?
Impugn order on page 34, lordship.
Yes, Mr. Goswami, get a report
get a
because
report,
the order of rejection was made on the ground that IO is investigating regarding the role played by the owner of the vehicle.
Lordship,
It was still on.
still on.
So let us get a up-to-date
Lordship,
status report,
lordship.
whether there was any role or not.
Yes, ma'am.
Right,
As
Mr.
per
Goswami?
FIR, lordship.
We'll not apply our mind much at this stage. Page 35,
Page 35.
second para,
Yes.
fifth line. Your role. Let us have a up-to-date report. Heard Mr. B. Chaudhary, learned counsel for the petitioner, and Mr. N.P. Goswami, learned additional public prosecutor for the respondent. Number 1, State of Assam. Who is this? Respondent number 2. IO.
I have lordship.
Not required, I think.
Lordship, can appear.
Agreed by. An order dated 23/7/2025, passed by the Court of Learned Special Judge Kamrup Amingaon Special Court, in connection with Hajo Police Station case number 179 of 2025, whereby a petitioner's prayer for interim custody of a vehicle from a Hyundai Venue bearing registration number AR-01/R-8715. Mobile also. I don't
Mobile
think
That's not belong to me, lordship.
a petitioner has preferred the instance.
I'm for the only vehicle, lordship.
Criminal petition. It is a revisable order, perhaps. Issue notice. Returnable on so and so.
17.
Goswami. Respond number 1. Issuance of notice to the respond number 2 at this stage is not necessary, as the learned additional public prosecutor is to obtain a up-to-date status report of investigation, including the investigation made in relation to the role played by the role relating to the owner of the subject vehicle, on the from the IO of the case, so as to place the same before this court on the revisal date.
Publish. For withdrawal, item 37.
Okay. Supply. Okay. Yes, Mr.
Yeah, maybe I'll have to withdraw.
Mr.
Yes,
Mojumdar.
yes, Akant.
AS?
Akant.
Okay.
With liberty to file.
Okay. Mr. A.S. Akanal and counsel appearing with the petitioner has submitted that the petitioner does not want to proceed with the criminal petition. Mr. M.P. Goswami, learned additional public prosecutor for respond number 1, has submitted that the state has no objection if the prayer is allowed. First of in view of the above submission made by Mr. Akan and counsel for the petition, and the criminal petition is dismissed on withdrawal.
For admission, item 18.
Why don't you kindly have the last order, my lord? Order dated 22/4/2025.
No, who is the husband? What is this? Maintenance?
Item 19.
May it please your lordship, this criminal petition is filed for quashing of the
Bit louder, man.
This criminal petition is was filed for quashing of FIR, charge sheet and cognizance.
Costing of FIR.
FIR, charge sheet and cognizance taken, my lord. FIR is a case. Page 16, my lord.
Who is the respondent number 2?
Notice was served, my lord, but notice was served, service is complete.
CR.
Now their husband, wife, my lord.
The charge sheet is under?
Charge sheet is under section 419, 376 and 506
Hmm.
items.
Then what happened?
Then cognizance was taken, my lord.
What is the case number?
PRC 1384/23.
1384.
Page number 27.
27. Charge sheet. Taken, cognizance taken, summons. Then what happened? 13. What is this? What is DV case number?
The opposite party number 2 filed a DV case against one because after the filing of FIR, the petitioner got married with the opposite party number 2, my lord.
So on that ground, you are seeking quashing.
And at the time of filing of the FIR, she was 24 years old lady, major. And
But where is the counsel?
relationship. I'm relying on Supreme Court judgment.
Can you bring the counsel for the respondent?
Lordship may appoint one.
As married wife, acknowledge such marriage was solemnized. Prior to that, okay, we'll put it on our next date on a fixed date. You get the counsel.
Your lordship.
EU law score. No. Not there. Service report. Yes, Mr. Kosik. What to do in this case? Service appears to have been served. Notice. And the petitioner is claiming that she is his wife. If respondent number 2 is your wife, then why none has appeared?
Notice is served, my lord.
A notice is served, that is your wife. If
My lord. That's why, my lord.
no, relationship by blood.
No, my lord. No. Distant relation. My lord, kindly see, my lord, my name is Altaf Hussain Chaudhary, a practicing lawyer, Karimganj Bar, my lord. List of dates, part 1, my lord. This case is filed by me against him, my lord. And it was after a long advancement, my lord. In advanced stage, he filed against me this one. My lord. Kindly see, my lord. 15/2/2020, Altaf Hussain Chaudhary paid rupees 2 lakhs to Shafiqur Rahman, my lord. On 2010-20, check of rupees 113,000 issued by Shafiqur Rahman to Altaf Hussain Chaudhary. Me Altaf Hussain Chaudhary, Altaf Hussain Chaudhary presented check to bank for encashment. On 21-10, check returned with remark, payment stopped by drawer. Then, my lord, on 29-10, check again presented by Altaf Hussain. In between the communication and all these things, but I am just giving the main important dates, my lord. Checks again presented by Altaf Hussain. On 9-11, my lord, kindly mark the date, my lord. 9-11, check again returned with similar remarks. On 17-11, demand notice issued by Altaf Hussain under section 138 against Shafiqur Rahman Talukdar. On 14-12-20, CR case number 30C of 2020 filed by me, my lord, Altaf Hussain Chaudhary, against him, my lord. From 15-12 to 20 to 4-5-2021, there were 9 dates, my lord. Several summons went, bailable warrant issued against Shafiqur Rahman, then he appeared. On 23-12-2020, reply to demand notice received, my lord. After his appearance, my lord, after the case being filed, my lord, I have received the reply of the demand notice from him, my lord, on 23-12. From 31-5-2021 to 30-10-2021, there are 6 dates, my lord. Consideration of charge date was fixed and it was came up for consideration of charge, my lord, on his appearance, my lord. Then 11-11-21, warrant of, again he missed, my lord. That's why warrant of arrest issued against Shafiqur Rahman. Again, he remained absent, my lord. 26-11-2021, Shafiqur Rahman appeared, allowed to go on previous bail. 1-12-2021, Shafiqur Rahman absent with step. Then, my lord, 21-12-2021, offense explained, Shafiqur Rahman pleaded not guilty. Thereafter, I have not proceeded on list of dates, my lord. The case is still in the stage of, my lord, evidence, my lord. Now, my lord, part 2, this is the impugned, my lord, case, my lord. Impugned CR case, my lord. On 18-10-20, his allegation is that on 18-10-20, date of alleged theft of checks, he said that once he went to my chamber and he, by chance he slept, and at that time I have stolen his checks, 2 checks, my lord, 2 number of checks, my lord. On 23-11-2020, alleged police GD entry made. On 31-12-21, CR case number 1277-21 filed by Shafiqur Rahman. This is the impugned CR case, my lord. Filed after offense being explained in my case. 3-1-23, initial deposition under section 200 CRPC, my lord, was taken there. Then 17-10-23, summon issued and Altaf Hussain Chaudhary on me, my lord. That is the basic part, my lord. Then case is still pending, my lord. Now, my
What is
lord,
your complaint?
yes, please. Complaint is at page, my lord, 22. My lord. Impugned complaint, my lord.
No, your
Yeah,
complaint.
my complaint is at page, my lord. At page 33, my lord. My lord, address is given in the page, first page. My lord, he is an employee, my lord. Shafiqur Rahman Talukdar is surveillance worker of malaria, subdivision medical health officer. He is a government employee, my lord. That the complainant is the neighbor of the accused, who is an advocate by profession. That the complainant was engaged by the accused to conduct this his MSc case by MSCT number so-and-so 2010 in the court of additional session judge FTC at Karimganj. As well as the complaint was engaged by the accused to conduct his own brother's case by title suite number so-and-so in the court of Munchip number 1 at Karimganj, so-and-so, so-and-so. That as such, the accused developed a good and friendly relationship with the complainant and often visited the residence of the complainant and set up a family relationship with the complainant. That in the month of February 2020, on 13-20, the accused requested the complainant to provide him a loan of rupees 2 lakhs, as he urgently need the same to purchase a plot of land at Patarkanti, Karimganj, with the commitment to repay the said loan within 2 months, i.e. on 15-4-2020. That as such, the complainant advanced the loan to the accused on 15-20, considering the good relation as well as considering the fact that both the accused and his wife is government employee, and as such, the accused could repay the said loan easily. That after availing the said loan, the accused have been maintaining distance from the complainant, and as such, after expiry of 2 months, the accused showed the cause of COVID-19 pandemic and lockdown and delayed the repayment of the said loan to the complainant. That after number of requests demand, the complainant demand to repay the said loan of rupees 2 lakhs. Ultimately, on 2010-20, the accused issued a bank check of rupees 113,000 only drawn on the bank account of the accused by account number so and so of the State Bank of India, Karimganj branch, duly signed by the accused in favor of the complainant, and accused sought further time of 1 month for the rest amount of rupees 87,000, that the complainant deposited the said check to his banker, the Punjab National Bank, Karimganj branch, on 20/10/20 for its collection, that the banker of the complainant returned the said check as unpaid on 21/10/2020 with return memo with comments, payment stopped by drawer. That the complainant immediately warned the accused about the development. That in turn, the accused replied to the complainant that the accused had some problems with funds and requested to deposit the said check on the next week for its collection. That the complainant believed such excuse of the accused on good faith, and again, as per the utterings of the accused, deposited the said check to his banker on 29/10/20 for this collection from the State Bank of India. The banker of the accused, that to the utmost surprise of the complainant, the banker of the complainant again returned the said check as unpaid on 9/11/20 with information that payment stopped by the drawer. That as such, the banker of the accused, the State Bank of India, Karimganj branch, dishonored the check by number so and so dated 2020, my lord, 20, this twice at the instruction of the accused. That as a result, the complainant and his banker failed to collect the check amount from the account of the accused as stated. That after getting back the dishonored check, the complainant contacted the accused over phone and asked him to reason thereof. The accused then told that he would talk after some time, and thereafter did not receive the phone call of the complainant. That the complainant then understood that the accused cheated him and misappropriated his money fraudulently with malified intention for his wrongful gain. That thus it is crystal clear that with evil and malified intention, the accused played a fraud with the complainant and cheated him for his
Preferred a
wrongful gain.
criminal revision petition.
My lord?
He preferred any criminal revision petition?
No, my lord, I am reading, my lord, the main.
No, come to page 47.
My lord, 47. Yes, my lord, it is what happened, my lord. After the initial, my lord, the stage is over, the trial court on my petition, my lord, ordered to pay 20%, my lord, as per section 147 of.
So what happened?
Against that, he went to the, for revision, my lord. The Savikuraman Talukdar, that is the accused, my lord. In that revision, it is remanded back to look at afresh. And now, my lord, the trial court is saying it is already in advanced stage, my lord, is going to decide it finally.
And what is this charge sheet?
Oh, my lord, this is this person is accused in some POXO case, rape case, and there are many cases, my lord. One I have annexed readily, my lord. This person is, my lord, not only accused in this case, there are many cases, 6-7 cases pending against him, my lord.
Now, where is his complaint?
Now, my lord, yes, my lord. His complaint is, my lord, at page 22, my lord. Type copy, my lord. Most respectfully, begs to inform you that the accused is a relative and lawyer by profession. For having relation with the accused, engage him to conduct my motor accident claim case. Having relation with the accused, I used to visit house of the accused at Karimganj and sometimes take rest at the house of the accused. On last 18/10/20, I went to the house of the accused along with a file bag. There were some important documents in the said file bag, including 2 number of signed bank check and Aadhaar card in the said file bag. I was so tired on that day, so while taking rest at the house of the accused, I could not understand when I fall in a deep sleep. Accused, taking advantage of my deep sleep, has stolen my 2 number of signed SBI check, bank checks bearing number so and so and Aadhaar card. After waking up from sleep on good faith, I left the house of accused along with my file bag. Having reached home, I put my bag in its proper places, but after a few days being felt necessity, when I opened my file bag, found 2 notes of signed SBI check and the Aadhaar card are missing from the bag. Then even after thorough searching, I could not be able to trace out. Consequently, I informed the Fatarkandi police station regarding missing of my important documents and goods. The GD entry of the said information being GD entry number so and so and 23/11/23. My lord, that is very important, my lord, for this case. Very, very important. 23/11/23. And as per the advice being given by the police, going to the bank stopped payment of the checks. On the other hand, accused being failed to withdraw money from the said checks after depositing the said signed check in the bank.
In your list of dates.
My lord, date perhaps, my lord, 23/11/20, my lord, not 23. 2020, this type mistake, my lord. 23/11/2020, my lord. GD&P.
Yes.
Yes, my lord.
So typing is wrong.
Yes, my lord. My lord, and advocate namely Hussain Ahmed, my lord, failed to withdraw money from the said after depositing the said signed check in the bank, served a legal notice to me through an advocate, namely Hussain Ahmed Tapadar. Having received notice, I could understand that while taking rest at the house of accused and taking advantage of my deep sleep, accused has stolen the said check and other card from my bag after the incident due to the COVID pandemic, and I being employee of malaria department and was being busy in COVID vaccine here, has been some delay in lodging of the complaint. That is the basically, my lord. Then, my lord, 200 statement by him, my lord, at page 26 and page 27, my lord. My lord, kindly come to the, my lord, legal reply to is the legal notice, my lord. That is also important, my lord. At page 41, my lord. My lord, I have received the same on 23/12/20. My lord, kindly see above in the left corner, my lord. I have received it on 23/12/20.
Page?
Page 41, my lord. Annexer G.
Yes.
I have the honor to submit the parawise reply to your legal notice dated 17.
Which part you want to show?
My lord,
Which part you want to show?
my lord, the part, my lord, the bottom, my lord. Last paragraph, it is pertinent, my lord. It is pertinent to mention here that two number of my SBI checks were lost in the year 2019, my lord. That is the point. Once he is saying that he lost it on 2010-2020 or 18-10-2020 in the complaint. Here he is saying checks were lost in the year 2019. And I visited from Patargandhi to Karimganj court to his residence, Karimganj settlement, and after searching and failing to find, I reported the matter to bank and also informed matter to the Patargandhi police. The bank authority has already cancelled the check number so and so in the year 2019, my lord. That is important, my lord. That is not remaining, is not important remaining, my lord. Now, my lord,
Yes, respect number 2. Wherefrom you are saying that this has been cancelled in the year 2019?
My lord, I have filed my affidavit, my lord.
File your affidavit.
My lord. It is marked as annexure flag A, my lord. in the
Hmm?
case report.
Yes.
Flag A, my lord.
There are two stories.
My lord.
One is that you lost the checks in 2019. And another story is that when you visited the petitioner chamber, he took out the
18
checklists from your bag,
October 2020.
signed,
That's it.
right?
That's it.
Now, what is your story in the affidavit?
My lord, nothing specifically denied. Entire allegations and grounds I have made in petition, nothing specifically denied. Not a single point.
My lord, all the fact that has been stated by my learned friend in the petition, I have denied, my lord.
No, that is denial is nothing.
Simple denial is not enough, my
No,
lord.
this is not repetition.
My lord. And my lord, my learned.
Because your instruction
My lord.
to stop
Yes.
the payment should have been in the year 2019 if you have lost the check. So where is that that you have instructed? In the complaint it was there. In the reply it was there. In the reply it was there.
My lord, in the complaint it is 23/11/2020.
Oh, that I have.
2020. And in the reply.
And there you put the
2019.
story that you placed the bag and went in sleep in his chamber.
Lordship.
And on the other hand, if it is a reply to your notice, page 41, there are two number of checks. Specifically, you said that these are the number of checks. And you have instructed the bank to stop the check.
And even the police also.
And even police. Right?
No.
So where is that instruction? Otherwise, two stories. Two stories, not
prima facie, my lord.
Similar to
Yes, contrary.
one, yes.
My lord, serious contradiction, one more is there, my lord. I like to point out.
So here contradiction is what, these two stories regarding stoppage of payment. This story and that story.
Stoppage of payment on the basis of, my lord, bank authority has stopped the payment.
Right, we have seen,
That-
but
that's
question
why, my
of
lord.
the instruction to stop payment is material.
One. And, while the, my lord, the petitioner presented the check before the before the bank, my lord, the bank authority declined to make payment.
No,
And-
that, if that is
And for
the,
that, my lord, he has filed the,
where is your check dishonor memo, sir?
My lord,
Your check dishonor memo?
my lord, my
That
lord,
has
my lord,
been
that is not annexed, my lord.
Huh?
that has not been annexed.
My
It
lord,
is part of the complaint perhaps? Is it part of the complaint?
No,
My lord, there is no annexer is mentioned, my lord.
You have mentioned, but
That
is
is
it
not
part
the-
of this petition? I have seen it is part of the complaint, photocopy. Check return memo, 21/10/2020.
My lord, kindly note one more important aspect.
Xerox copy, 1 minute.
He's not denying anything, my lord. Nothing is denied there. So. He's admitting that he has returned, my lord.
no, no.
Is the evidence stage is over?
My lord,
No.
he has yet not been started, my lord. In the impugn matter has not yet been started, my lord. My lord, kindly have a look, my lord, on important
My lord, the
serious contradiction. Your lordship will be satisfied. I think, my
learned
lord.
court below, my lord. Still.
Yes.
Huh?
My lord, kindly see, my lord. If stop payment is made on 23/11/2020, my lord, according to him, in 2020, how the bank issued the return memo on 21/10/2020 and 9/11/2020. Before he's saying that he issued stop payment on 23/11/2020. But my return memo is with note that stop payment is coming return on 21/10.
What are these?
My lord, before the date.
Do you have this document, page 39?
Page 39.
Seal number 1, 2, and 3.
No, my lord, not with me, my lord, not annexed, my lord. Not with me, my lord.
Because you are annexing those documents.
My lord, your lordship, very much true, my lord. But thinking
No,
that, my lord, if my
Contents of the return memo. You
Yes.
said exchange arrangement or payment stopped. 21/10. So 21/10/2020. So there may be something different. He said 18. Definitely the instruction was much earlier to that.
Yes, my lord, that is my, I'm saying, my lord.
21/10/2020.
According to his complaint, my lord, he has, my lord, make stop payment on 23/11/2020. And
Could not be, that is why if he says that 23/11/2020,
my lord,
and you're saying you as per your list of dates, on 21/10/2020, the check was returned unpaid with remark, payment stopped by drawer,
my lord.
right?
Yes.
So might have been earlier to that.
Exactly, not matching with the date, my lord. Not matching with the 23/11, my lord. As he claimed in the complaint.
Whatever, but it is a fact that instruction has been placed perhaps much prior to 21/10/2020.
Maybe, my lord.
Where is the document? To
My
have
lord,
a look,
I've not annexed, my lord.
that
But
is, we have to look at it.
my lord, then I have to obtain it, my lord.
Right, you have the documents.
Yes, my lord.
You have selectively,
But if my learned friend is not denying
instead
it,
of annexing all these POXO cases and all, you should have annexed the complaint in total. At least to inspire the confidence of the court.
my lord.
You have annexed unnecessary documents
Ye-
that he is an accused in
Yes,
POCSO
yes,
case and
yes, my
all.
lord. Not even related, my lord, with this case.
Right? We are into two complaints. That's all. Whatever his conduct, whatever is your reputation in a bar, we are not concerned with it. As an advocate, we are concerned with these two cases. So he may be a history sheeter, whatever. But we have to see that whether this complaint, second complaint, subsequent to your complaint, is fit enough to be quashed.
My lord. But my lord, so far as the affidavit is filed, my lord, and the reply is filed, my lord, the reply of the accused, he's saying that he's admitting it.
Mr. Talukdar,
My lord,
this is a criminal proceeding.
my lord,
We have to go by the materials on record.
my lord.
We are not going by the statements and denials. We are not dealing with written statements.
My lord.
It is not a civil suit.
My lord.
You have to establish your case from the materials. Document speaks better
Yes, my lord.
than man.
Yes. One time, maybe.
Another, my lord,
Document does not lie.
But-
Man lie. Right?
My lord.
Document number 1, 2, 3. You
Well, I'll
bring it
produce-
on record.
I'll produce sometime maybe
Better.
given.
My-
Because I thought that, my lord, he is not denying his reply, that's why maybe not.
No. Because the payment stopped by drawer was earlier to the presentation of the check.
Yes.
Earlier to, and when it was served,
My lord, the demand notice, my lord.
is there anything, whether the first, okay, you presented it first, then again second time,
Yes, my lord.
right?
That is mentioned in my demand notice, my lord, details, my lord.
So before first presentation,
My lord.
the instruction to stop payment was there.
It appears so.
yes,
Yes.
Yes.
Document does not lie.
yes, yes, my lord.
I said,
Yes.
document does not lie.
Does not.
And bank record would not lie.
My lord.
So it was returned with payment stopped by drawer. So it, and check was dated 20/10/2020. So it might have been earlier.
Yes,
He said sign check and filled up by you.
yes.
And what did you say in your complaint?
My lord, in my complaint, my lord, it is page
When the check was given to you?
starting from page 33, my lord.
When the check was given to you? Ultimately on 2010.
Yes, my lord. And same day it was, my lord, placed before the bank first time.
So 2110, it was dishonored.
My lord,
Payment stopped by drawer.
yes,
Check was given to you on 2010.
2010.
If the instruction is prior to that,
Prior to that.
could be prior to that.
Definitely it will be because otherwise bank cannot say so.
Something is not telling, matching.
Yes, ma'am.
My lord,
Something is, the things are not falling into places.
my lord, yes.
To find out that the check return memo it will be there. And had it been a case, is there any evidence? No.
No,
My
As
lord,
on date, in the complaint case,
in
your complaint case.
in my complaint case, my lord, not annexed, but
Not
it is advanced to a, my lord, the.
No, advanced to what stage?
Yes, my lord, I am giving it. Lastly,
not an.
cross-examination of prosecution witness, last, on 4/10/20.
Now, what is the, whether bank official has been examined
No,
My lord, I have seen.
from his bank?
Perhaps not, my lord, cross-examination of prosecution witness, my lord, perhaps
Because
not yet.
had the bank official
Hmm.
from his bank
Yes,
is examined by you,
my lord.
right? He could have said that payment was stopped by so-and-so on so-and-so day. Have you understood my issue?
On so-and-so date, he did not.
Come to your that page, come to that page. Your complaint, last page. We are not here to appreciate the evidence, right?
My lord. Page 39, my lord.
Page 39. And you have made this man, your bank is what?
Punjab National Bank, my lord.
State Bank of India, Karimganj branch. I
Karimganj.
think he's banker.
My lord.
Whether this man has been examined.
This is not clear from the, my lord, from the online report I collected, my lord. This is not mentioned just for
If somebody from this bank has been examined, then his evidence will be material.
My lord.
Whether it is 2019 stop payment or 2020.
My lord.
On what date? It could be that, as per your story, on 20 October, he should have checked. And at the same time, he went to the bank, stopped the payment.
Yes, maybe.
Then it is a case in your favor. But if it is in 2019, as he said, in one place,
My lord.
it could be a different case.
Different.
Yes.
We cannot appreciate to that extent in a criminal petition. Find out, get the 3 documents. We can have our mind. If it is satisfied, we satisfactory.
My
we will
lord,
apply.
perhaps the
Perhaps
main matter is yet not been cross-examined, my lord. Not yet been.
find out if it is cross-examined.
It may take. It
No,
may take time.
examination in chief, because
My
he will
lord.
speak from the records.
Yes, my lord.
That will be material. Might be enough
My lord,
to set aside was the second complaint.
Then my lord, real picture will come to light, my lord.
I don't know.
Yes.
my lord.
Both of you know the truth, right? And this court only
Not that, my lord.
does not know the
My
truth.
lord,
That
not-
is the
My lord, not
actual
that.
picture. Both of you
No, my lord.
know the truth,
Not that, my lord.
right?
I do not know that.
That is the reality.
Not that, my lord.
What had happened, what had transpired between you two, both of you know.
No. Not
Right?
exactly, I cannot say that.
And
But I
like
have
said,
confidence
it
that-
is the court who is on trial.
I know that both of them have some dispute only, that much.
No, but both of you know the truth. It is a fact.
No. And my lord, my learned plan.
No, Mr. Talukdar, you bring this 1 to 5, page 39 on record.
My
Plus,
My lord, my
plus,
lord.
if any witness has been examined, right,
Yes, my lord.
from your side,
My lord.
try to bring it on record. We'll see on that basis whether the second complaint should be allowed to go on or not.
My lord, I'll try, my lord. Perhaps it
First-
will take the time to. My
No, 1 to 5,
documents
1
we
to
can.
5 is available.
Documents I can, my lord.
Huh.
Documents I can, but if the.
No, I am suggesting you bring it on record if it is available. You also don't know, heard Mr. A. Talukdar, Land Council for the petition, and Mr.
TU, let's come.
Myself and Mr. Public Prosecutor, they do not know the correct position. Talukdar and Mr. Loskar both know.
I myself asked in some English.
TU Loskar, Land Council for the respondent number 2. Post up. Mr. Talukdar shall bring on record the documents listed in the complaint by way of an additional affidavit. Post up. In addition, comma, if any witness has been examined in CR case number 38, Uparot C, stroke 2020. From the complainant side, comma, the same can also be brought on record to the said additional affidavit. Lays the case on as prayed for on. Take it on in September. Which date?
My lord, may I pray a small prayer, my lord? On the first day, my lord, I was told by, it was an understanding that when I pressed for the stay of the proceeding, so then let us, the other side appear. So it will be almost an
Take a
useless,
date.
my lord, September. Maybe on my lord,
Next day.
first week or second week, my lord.
Choose a date.
9th of, my lord.
Okay, 9th.
Obliged.
Obliged. Item 21,
Santa. Yes, what has happened to?
My lord, we have filed an additional affidavit, my lord, regarding the compromise, my lord. It is marked as flag C.
Flag C. Santa Gogoi.
Matter has been
Other
settled.
side is Banta.
he is for the Santa Gogoi petitioner.
Okay, where is the complaint? Where is the complaint?
Mean to
Complaint, my lord, regarding the
Yeah,
Quashing complaint, NI case number
yeah,
53/2023.
Gurgaon.
third from
Complainant. Yes, Sabtaba Santa Gogoi.
page 24.
Santa Gogoi. Barola. Okay, let us have the additional affidavit.
It was filed on 12/8/25.
Yes,
Your Lord.
Mazumdar?
Yes, Lordship. It seems that there is a compromise, Your Lordship,
Hmm.
but I could not ascertain from my client because after the expiry of her husband, she is not responding. Even
Who is your
today,
client?
the respondent number 2 and 3,
2 and 3.
husband of,
Yasab Taba.
yes,
Gurgaon.
her husband expired, Your Lordship.
Hmm?
Since then, they are not responding.
But complain, as per
They-
the complaint, she was the complainant.
Yes.
In the complaint, she was the complainant.
Yes, Your Lordship.
There is nothing to do with her husband.
Yes.
And Nirmali Sukrang. She was the Sukrang or whatever, that
She is the attorney.
she was the attorney and
Yes.
she signed the deed of compromise,
Yes.
right?
Yes, it's. And her.
So what do you
signature-
say?
Her signature is also seem to be,
Are you in touch with Nirmali Sukrang?
I could not, even today I repeatedly called, also send a WhatsApp message, but I could not
Then let the matter be fixed another day.
contract. Perhaps,
Okay, I heard Mr. D. Bora, learned counsel for the petitioner, and Mr. R. Mojumdar, learned counsel for the respondent number 2 and 3. Post up. Mr. Mojumdar,
এটা নধৰিলে কি কৰিব এইটো আপুনি
learned counsel for the respondent number 2 and 3, has submitted that he'll obtain instruction as regards execution of the deed of compromise dated 22/7/2025 within a week's time. Full stop. As sought for, place the case on
27th.
27.
And the national lower court case is pending there.
If it is settled, then settled.
otherwise,
He settled, my lord, but he had.
otherwise, Your Lordship, this.
Maybe Mr.
signature-
Mojumdar is not getting
Yes.
material instruction.
But
They have
1 week's time
there
is
is,
granted.
there is the difficulty, Your Lordship.
1 week's time.
Otherwise, the signature seems to be genuine, Your Lord.
Next 2027.
Obligation.
Is that matter, my lord, complaint had been.
I forget.
May it pleases your lordship, matter may be passed over for the day, lordship. Mr.
Why?
Counsel for the respondent, Mr.
SP Chaudhary.
Yes, he is having some difficulty today, lordship.
But when
Side
complaint
of
gets
matter.
dismissed, my lord,
Huh?
when complaint gets dismissed, whether 256 CRPC acquittal will come or not.
Oh. Okay.
Yeah.
Latest judgment.
Yes, ma'am.
By Justice Datta.
This is up to them.
Okay. When?
On
Next
any
week?
date, any date in the next.
A cycle
First week
next week from 1st of September.
First week of September, my lord, next week.
1st of September?
Yes.
Okay. Mr. Asnawaz, Learned Counsel for the petitioner is present. Miss
B. Debbie, lordship.
B. Devi, Learned Counsel appearing for Mr. SP Chaudhary.
Yes.
Learned Counsel for the respondent has submitted that Mr. Chaudhary has some personal problem today. And the case be listed on another date, first of as sought for and agreed to. List the case on 1st of September.
Deeply. Item number 24 and 25.
This is that extension case, my lord, when notice was not served. It had come up last Thursday, my lord. Lordship had already heard. NDPS case, my lord, so extension was beyond 180 days. extension was
Yes. Sharma.
My lord, I have also checked, my lord, that record, my lord. That, my lord, such type of notice, my lord, I have not found. Any
What
notice
was the
to the
law?
accused.
Last occasion, my lord, Sanjay Dutt's judgment was not eligible, my lord, so I have got an eligible copy. First judgment, my lord, Hitendra Vishnu Thakur, my lord. Others are there in the record, my lord. Hitendra Vishnu Thakur.
Page.
Sanjay Dutt, my lord, para 45, my lord. Internal page 440.
45.
45 minutes. Oh.
45 is
The submission, my lord, then pay para 53, 2A, page 444, my lord. 444. 2A, my lord.
53 2A.
2A, my.
And where is that, somewhere it is mentioned to the council?
Council judgment, my lord, I have
I-
not been able
it
to,
is
but there's a
there.
judgment, my lord, council.
I think it is there.
Yes, my lord, that is also there, that I could not furnish. Hitendra Vishnu Thakur says notice, Sanjay Dutt says written notice not required. Physical production is sufficient.
Let us have the full.
My lord, my lord.
One minute. Earlier one was illegible, right?
Earlier, Sanjay Dutt was not legible, my lord.
I think good file na lage. You say it was Sanjay Kumar Kedia?
Sanjay Kedia is, my lord, specific to NDP.
1 minute, NDPS.
Para 11.
Record to sound. When was the order made?
3rd of, my lord, 3rd of June, my lord.
Application was made on 2.
2nd.
3rd of June.
3rd of June.
2025.
25 minutes.
And on next date, on 4th, he was released.
What is the name of the petitioner?
Anjar Hussain.
Anjar Hussain. What is the date of the release order? Sorry, what is the impugn order?
Impugn order, my lord, page 41.
No, date.
Date 3rd of June, 3/6/25.
3rd of June.
3rd of June.
Where is the petition?
Petition, my lord, page.
There's a flag mark, my lord. Last one. Handwritten,
Handwritten.
my lord.
Can you get hold of the judgment that counsel is to be?
I tried on the last day your lordship had indicated,
Oh.
I could not find it, my lord.
No, I have read it. That is why I am.
Well, I understand, but
I read it, but where I have read it, I forgot. But Supreme Court. Supreme Court. Find out tomorrow, we'll take up. Okay. Right? Paribo na report? Paribo. Okay, list the case tomorrow. As Thomas B. Sharma.
Can it be day after?
Tomorrow, huh? Day after tomorrow. then.
Day after.
Find out that. Apart from deciding the case, I want to know also the exact position. Hardly any time to research.
Deeply obliged.
two.
Item 26.
Yes.
My lord, here I am for the respondent number 2, my lord. My lord, this petition has been filed out of some misconception of facts, my lord. So.
Petition or FIR?
FIR, my lord. My apology, my lord.
Petition, then it is dangerous.
My apology, my lord.
Ah.
So, my lord, I just, I'm not, I don't want to pursue this matter, my lord, for any before so.
Who is FIR?
FIR. Page 9 is the
Nine.
type copy and the main part is page
Hmm.
15.
Toronto tape. Arnicular?
Page 9.
Oh, good. Plus. Yeah, BNSS one. এটা দেখা বলে BNSS. BNSS also. Hmm? Case 60. So except one offense, all are non-compoundable.
My lord.
Huh?
Yes.
318 subsection 4, that is only compoundable.
Yes.
Yes.
Third, Mr.
Because
G. Kaushik, learned counsel for the petition. Yes, Mr. Sharma?
This is my lord. Seeking forgery and my lord criminal bishop trust. That is only my lord 318. Others are my lord not compoundable.
Not compoundable.
But affidavit my lord
Affidavit is there.
is there.
FIR is also short, affidavit is also short.
Oh, very short, very short.
Like additional public prosecutor for the respondent number 1, comma, state of Assam. And Mr.
A.J. Sharma.
A.J. Sharma, learned counsel for the respondent number 2, post of para, the instant criminal petition under section 528B NSS is preferred seeking, setting aside, and crushing of a first information report registered as by Hatta Sarili Police Station. Case number 83/2025 on 1/4/2025 and all consequential and subsequent criminal proceedings arising therefrom. Full stop. Para. It was the respondent number 2 had in as the informant who lost the first information report before the officer in charge by Hatta Police Station on 4/3/2025. Naming the petitioner herein as accused number 1, along with a Latmundal from the office of the circle officer, North Guwahati Revenue Circle, Amingaon, Guwahati, as accused number 2, post of para. In the FIR, the respondent number 2, that's informant, had inter alia alleged that he is a resident of Guwahati. No, he has been residing in Guwahati in view of his service. Poster. He further stated that he had a plot of land measuring 3 kathas, 9 lasses, covered by Act number 143 and but a Kiras appeared Kiras AP Patta number 291, situated South Lenga village, Moza Bangshor, North Guwahati Revenue Cycle, District Kamrup, within a subject plot. First off, the respondent to this informant further alleged that without his knowledge, the accused number 1, with the help of the accused number 2, got her name mutated in the revenue records. And also took possession in connection to the subject plot, and also took possession of the subject plot. First of suspecting that there were also involvement of other persons. The respondent number 2 as informant requested the police authorities to make necessary investigation. Post of para. On receipt of the FIR, the officer in charge entrusted the sub-inspector of police attached to Baihata police station to cause an preliminary inquiry. First, the sub-inspector of police, after causing a preliminary inquiry, reported on 1/4/2025 that there was a privacy case which should necessitate further investigation. Post op. Thereafter, the FIR had been registered as Baihata Police Station, Baihata Sarili Police Station. Baihata Sarili or Baihata? Baihata Sarili ho sake. Baihata Sarili, huh? Police Station. Case number 83/2025 for the offenses under sections page 11 was 318 within bracket 4 section will be dated but in aid of section 3 within bracket 5 of the Bharatiya Nyaya Sanhita. Post of para. In the investigation, it is stated that the investigation is being carried out at present. Post of, but the respondent number 2 as informant has shown an affidavit on 4/7/2025 stating that he had filed a FIR on 1/4/2025 before at the Baihata Sarili Police Station, registered as Bayata Posaile Police Station, case number 83/2025, out of misconception of facts and misapprehension. Full stop. In the affidavit, the respondent number 2, that's informant, has further asserted that he does not want to proceed further with the case. And he is doing so at the cost of the necessary consequence. Full stop. Para. Mr. Sharma, learned counsel appearing for the respondent number 2, that's informant, has submitted, has affirmed that the affidavit annexed to the present criminal petition, as annexer Roman 3, is an affidavit which has been sworn by the respondent number 2, that's informant. So he has further submitted that the respondent number 2, that's informant, is not interested to pursue the matter further. Full stop. Para. On a look at the FIR, within bracket annexer Roman 2, Roman 2 in again, Roman 1, it is seen that save and accept the offense under section 318 within bracket 4 B and SS. The other offenses, namely other offenses, are defined by section 3165, 336, 3, section 338, section 337, and section 340 within bracket 2 of the BNSS are not offenses which can be compounded under the provisions of section 359 of the Bharatiya Nagarik Suraksha Sanhita. Post stop. The provisions of section 359 BNSS and section 528 of provisions of section 359 and section 528 are akin of the BNSS are akin to the provisions, akin and parametry to the provisions of section 320 and section 428 of the Code of Criminal Procedure 1973, the code of the CIPC. Full stop. The Narendra to assign Narendra to Narendra Singh to assign to us. Narendra Gyan Singh neki. As the petitioner, respondent number 2, as the informant, has affirmed and asserted that he is not interested to pursue the case further, and and comma, the possibility. I'm sorry, the matter of investigation. Even if it resulted in submission of a charge sheet, comma, is not going to serve any better purpose, fruitful purpose. If the respondent number 2 dash informant is not going to support the case of the prosecution. Post as a result, comma, the possibility of the case resulting in conviction is remote. Full stop. The fact that the respondent number FIR lodged on 1/4/2025 is a result arising from misconception of fact has been affirmed and reiterated by the respondent number 2 dash informant in the affidavit sworn on 4/7/2025. Full stop. By him লিখি দিব paragraph তাৰ আগতে লিখিব the in-hand powers of this court can be exercised in an appropriate case in order to secure the ends of justice or to prevent the abuse of the process of court. Full stop. In cases as the offense alleged by the respondent number 2 dash informant against the petitioner is in respect of the subject plot and in a sense, comma, the dispute is primarily of civil nature, comma, this court is of the view that the case in hand is a fit case to exercise the in-hand powers under section 528 PNSS to set aside and quash the FIR registered as so and so, and all consequent and subsequent proceedings arising therefore. It is accordingly ordered, huh? Baki paragraph likhi dibo. Like civil petition is disposed of in the apostolic terms.
Supplementary list, item number 38.
May please, Lordship.
This is the application lordship against an order passed by the on a trial before by the pair of the
Yes, some report. Some report.
report was for lordship.
Custody vehicle.
This lying since 20.
Where is the order?
My lordship will find it at page 19, lordship. Annexer E, lordship.
What is the FIR?
Lordship, after page lordship, to lordship. Page 12.
I lost on lordship 22nd of February and my vehicle was seized on lordship of April.
Which vehicle is seized?
Lordship Swift Desire lordship. But
Huh?
you will find the type copy lordship at page 14 lordship.
It is not mentioned in the
Yes, yes,
FIR.
lordship. Petition against lordship to
Huh?
specific vehicle lordship. Regarding
It is
transportation of illegal
419.
cattle. That is the accusation lordship as per the
Huh?
FIR.
There are two trucks.
Lordship.
Then how this vehicle?
And my vehicle was
Page
seized on
15, page
11/4.
15.
Lordship.
Swift Desire.
Yes, lordship.
Huh. It was seized when?
It was seized on 11/4/2023 lord.
Where it is mentioned?
Lordship, just a table, we will,
Hmm?
below the tabular column lord.
Seizing officer. 11/4.
11/4 lord.
Offense
Offense lordship, that was 2nd February.
22nd February.
Right.
Swift Desire. Mukib Ahmed. And your name is there in the FIR?
No, lord.
Huh?
No, lord. There are 3 accused lordship. Saiful Islam, Rafiqul Islam, the other accused. Address not known. Holding phone number shown suspension. The case is pending at the stage of the evidence lordship.
Search is submitted.
Lordship.
Let us see the search sheet now.
Lordship will find that type copy starts from 22 lordship. Original lordship at page starts from 26.
In a search sheet, where is your vehicle is mentioned, serial number? Where is your vehicle?
Page 27, my lord.
27.
But it's
Which
very-
part?
My lord,
Serial number?
from below it's third. One Swift Desire car BR number.
Number 2.
Hmm?
Serial number
Third.
From below, my lord.
from below.
Below. Page 27.
27.
27.
From below. At the last, it was one Wagoner.
Lordship.
My document is correct.
My lord, this side, my lord,
Which side?
this side from below.
This side. Okay. Okay.
Indian currency,
Then,
Indian currency note, then Swift Desire.
okay, he is concerned with the Swift Desire only.
Lordship.
My lord.
Report, because this is cryptic. The order is also cryptic.
Cryptic and the order, my lord, I have seen.
Cryptic and short.
And the order that the honorable court has, my lord, mentioned that is required for trial. The word is trial, not for investigation, my lord. So
Any reason?
No.
no.
Huh?
Actually, I have seen for the first time, my lord.
You are supposed to produce a report.
Yes, my lord, but the
Because
only
why
thing,
trial? Because
my
last
lord-
two occasions.
yes, my
All
lord,
of it.
actually, once they have sent us this report, maybe there is some miscommunication or maybe there is because the word is
When
trial.
is the order passed rejecting?
And 3rd of January, Lordship, 25.
This man is not an accused.
My lord.
And it was not intercepted and seized.
My lord.
There is nothing on record
On record.
that in his vehicle, this cow, any
Yes.
36 cows or bullocks, whatever, was found.
Yes.
This vehicle was seized after 2 months. Why? We don't know.
My lord.
He is not a charge sheeted accused,
My lord.
right?
My lord.
And it is not even a DPS case.
My lord.
There's some chamber.
Yes.
A cow cannot be put in a secret chamber inside a
Sweet.
Swift Desire vehicle,
My lord.
right? So why? It is surprising for us.
My lord, last question on 29/7/25. My lord, they only sent us this, my lord, where they have said that, my lord, the charge sheet has been submitted here.
That is already part of the.
Yes, part of the, and the only thing is that, man, since now the honorable court has said that, man, it is required for trial now, whether IO can,
No, okay.
my lord, because
You want to say that. And so far, I think there is one judgment that once it is trial, the court has to exercise the power under either 451 or
57.
457. 451. So if this is the nature of the order, then that
Ambala.
famous case 2002,
Ambala.
Ambala,
Ambala.
will come into place.
Lord Ambala. Yes, that will come, my lord.
Huh? Anything more required?
My lord. Because of this order, I cannot say anything because the court has.
That is very cryptic also.
Yes, my lord, because the court has, in fact, my lord, myself, I was thinking, my lord, if I seek something from the IO also, he cannot write, my lord, because it will require for investigation, because the court has written that it is required for trial.
Okay, we'll put it, that without any reason, we'll set aside this order,
My lord,
send it back to corporate, because we are also not aware.
my lord.
But this is without reason.
Yes, my lord.
Okay, tomorrow we'll pass the order at morning. At this stage, it is very difficult to exercise. Okay, Mr. B.K. Gogoi. Petitioner. R. Kosik. List the case tomorrow. List the case tomorrow. And endeavor will be made to consider, to make final consideration. Will dispose of it, setting aside the order, that is a cryptic one.
Because very only 2-3 words.
Cryptic one, but
Yes.
without knowing the real facts, we also cannot,
Yes, yes.
because every judicial order has to be with reasons.
Yes, ma'am.
That reason is missing.
In fact, the report regarding no mention of report also. No mention of report also in the order. Right?
Nothing,
Nothing, please.
nothing.
Nothing.
It's very difficult.
Yes.
Also to arrive at any opinion here,
Yes.
we'll set aside, you make a prayer, we'll say this will be guided by Ambalal.
Obliged. Item 27 for orders.
May I please, your lordship.
Scan copy legible. POXO,
By one, by
serve notice opposite party. As regards service of notice upon the respondent number 2, as regards service of notice upon the respondent number 2 from the jurisdictional officer in charge, Soyang Police Station. Raise the case accordingly on Friday.
22-8.
obliged, lordship. Keep the-
Item 28.
Order. Why it has come for order?
Service, my lord. POXO case.
POXO.
My lord, I have been verbally told, my lord, just now, service complete, my lord.
Okay, when?
My lord, that report I have not got yet, my lord. Otherwise verbally.
Same
told.
thing then Friday.
Right.
Mr. PD Chaudhary.
PD Chaudhary.
Okay, I go to Nishna Friday. We'll get the report,
My
then
lord,
we'll
Friday.
proceed further.
29.
Miss, please, your lordship. The section 5 limitation.
Issue notice, accept notice, registered post. What is the offense, conviction?
138th NIC, madam.
138,
138th, madam. So interesting here.
57 days.
Yes, madam.
Service is complete. Steps taken,
Yes, madam.
but service is not complete.
Madam, we have taken as acted by none.
Have you seen the office note?
Yes, madam. I noted down, madam.
Mr.
My lord, NI
All right, so it is difficult.
difficult.
But interesting fact is that he had paid much 3,50,000 against the
I can understand, Mr. Gogoi,
my lord.
Mr. S. Gogoi.
Yes, my lord.
Okay,
He's a
learn it.
teacher, my lord. He's a teacher. He has been suspended. He's a headmaster of LP school, and he has paid 3,50,000 out of rupees 5,30,000.
No, you are the accused,
Yes, my lord.
right? You have been convicted.
I have been convicted.
And Mr. R. Kosik, Learned Counsel, Additional Public Prosecutor for the opposite party number 1, State of Assam. Peruse the office note, dated 16/8/2025. Await for the service report. List the case on after 2 weeks detail.
Item 30.
Made please, Lordship, this criminal petition has been filed seeking Jima of the coal in relation to Lekapani PS case number 32 of 2024. Lordship, on 28/7/2025, Lordship was placed to pass
One
papers
minute.
to order, and Lordship was directed to for submitting of the report. Lord. In connection with
Yes, yes.
Lekapani
Mr.
34.
Goswami.
Yes. So we received the report, my lord.
Hmm.
And Lordship, in one more fact, I need to bring for your lordship is that after your lordship's order on 28/7/2025, the petitioner's premises, lordship, it was full with 1100, more than 1100 ton of coal. Now this has been vacated after your lordship's order.
Means.
Lordship has directed
Father
to
William
maintain
so
status quo.
seized by seizure list. That was it for your reason. Meant to record the claims of a petition number so and so. So, earlier, as per a report of the IO,
Yeah.
it was auctioned,
Auction.
but it was still lying.
In the
As per
premises.
the. Yes, my lord. Lordship may kindly come to page 286. Then your lordship may throw some light on the matter for the case. 286. The last Jimma order, my lord.
280?
286 of the petition was. The IO has stated that part.
And in the report of the IO lordship, it has been mentioned that it is the petitioner's word was by the Muhammad Tajib, the present petitioner.
That is why I asked for a full copy of the report.
Yes, yes.
Full copy
Full
with
copy.
all the.
Yes, it has been received, my lord.
You have received?
Lordship.
What does it say?
It says, my lord, the coal that was, my lord, it was auction, my lord.
Auction
And
in
auction,
what
and
manner?
thereafter, my lord, they have made the payment, my lord, person who has thrived in the auction, my bidder, my lord, highest bidder. And thereafter on, my lord, order was, permission was granted to leave the coal, total quantity such and such, my lord. On that is on 7th July, my lord.
7th July.
July. The order of 7th July. And my lord, there is detailed report, my lord, regarding payment, my permission to auction, thereafter permission to.
Please a copy. Please a copy.
There are several cases, my lord, so I have flag marked the relevant parts.
What happened in this case, lordship? The petitioner earlier approached for grant of Jimma in Lekhapani PS 35 of 2024. Thereafter, it was rejected. Then we approached the High Court. After the High Court's order, we have been granted the Jimma. Then when the Jimma was granted, the IO informed us that it has been the coal lying in the premises has been placed in connection with Lekhapani PS 32 of 2024, not in 35 of 2024. That is why we have approached this, again, we have approached the Chief Judicial Magistrate Court, then we are against the rejection order, we are here. We have never been put into notice that this auction has been going on this about this seizure or nothing also. When we get to know about the seizures, we went for filing in Lekhapani PS 35. And at that time also, never it was informed in the court that it has been seized in 32. In the High Court also, no, neither in the learned SDGM court.
First page, you also may kindly say report. The last paragraph is the my relevant report, my lord, regarding 32, my lord.
We are concerned with 32.
32, my lord. Now we are on 32, my lord. Last part is of 32. This is the permission for my lord, auction, my lord.
What is this?
This is the my lord, payment, my lord. Payment by the my lord, highest bidder, auction bidder.
This coal
Lordship,
of section case number 32
lordship.
stroke 2024 was
Yes.
lying where?
The petitioner's premises.
Oh,
Lal Pahar
village,
Coal
village,
Depot.
village.
Village, it is Lal Pahar.
Lal Pahar Pathargaon.
Lal Pahar.
Lal Pahar. my lord.
1339 metric ton
Yes,
from Lal Pahar Gaon
yes,
has been auctioned.
lordship.
So 47 lakhs,
Lordship.
perhaps.
Lordship, that is the payment.
And Lordship, initially when we approached this honorable
And
court in
thereafter, your
Lekhapani-
lordship will find the
Lekhapani PS
We
35.
are examining the facts only,
lordship.
And
not
initi-
submission.
Yes, initially when we approached Lordship, there was a stay order in the auction also, Lord. In Lekhapani's PS 35, because we had the knowledge that this coal is seized in Lekhapani PS case number 35 of 24.
Here was a stay order. Regarding 35, it is different, madam. Now we are on 30.
When is your stay order?
Now we are, because there, your lordship.
No,
will
when
find
is your stay order?
35 and
Lordship, if
32
my-
is separated, my lord.
No, one
Lordship,
minute.
that interim order, Lordship, I will, it's just.
When?
Lordship, it is in 11/11/2024 in criminal petition number 1349 of 24, Lord. This has not been annexed, Lordship, here.
Page, my lord, 271, my lord. I have find one order, my lord.
This is the copy of the report dated 10/7/2025. This is 16 August.
Yes,
We asked for also the report dated 10/7/2025.
Yes.
And this is the report for Lekhapali Police Station 35. We are concerned with 32. Is it not?
32,
Yes, sir.
yes, this is, my lord, perhaps it is by the, our office, perhaps, or
Huh?
my lord.
Lordship,
Because,
they
my
have
lord,
always confused also us.
because,
also.
my lord, there, your lordship will find there is, it carries the report of all the police stations, man. That is why, in the
No,
last,
it is not specifically mentioned.
In the
32
last-
is never mentioned here.
your lordship may kindly see the last portion of the, my lord, there, where I have flag mark, my lord. This is regarding your lordship. There is also 35 is also mentioned, my lord, but that is not the case. In 35, there are separate seizure, my lord. In the-
What is this? What is this
Yeah,
one?
this is a chart, my lord, regarding,
Because no head or tail, so.
yes, no, but I have seen the, in the last, below portion, my lord. My lordship will find regarding PS case 32, my lord. 32, 35, everything is there, but we are concerned 32, my lord.
Where is that impugn order 10/7/2025?
Hence,
Page
your
286.
lordship,
Lordship.
286, my lord.
286.
Lordship.
And there is a report, I think 10/7 somewhere.
Yes, Lordship.
Yes.
There was the case record report dated 10/7/2025, submitted by the IO.
Lordship.
We also asked for that report.
Yeah, yes, that report, my lord.
That report was not.
10/7, along the documents which is,
Can it be said there is a report?
Yes.
Can it be said as a report?
No, I'm not saying about that, my lord, the entire, my lord, because,
Can it be said is a report? What is a report? Meaning of report?
yes, that,
Meaning of report is not chart
yes, my
without any kind of signature.
lord. Yes, my lord, yes. Yes, my lord, that is it, my lord. Your lordship will find in the first page, my
No
lord,
head,
yes,
no tail.
yes. He has,
Mention of 32 is there.
yes,
But it is not a report. I don't think district judge, session judge has misunderstood this as a report.
no, my lord, because these are the documents that has been next with this, my lord, report, my lord, because this is a report of, my lord, this report.
Yes, we
that
could,
is
we could,
annexed-
we could decipher that it has been auctioned.
Auction, my,
That much we can decipher,
yes, my,
right?
yes.
And lifting order is given, but nothing, 32, except here.
In the, my lord, petition 288, it is a 10/7 report has been given, my lord, and it was
Who is
asked,
it?
it was,
Sir,
it was,
Swami, on 28/7/2025,
yes,
we
Your-
asked for a full copy of the report
Yes.
dated 10/7/2025, submitted by the IO of Lakhapani Police Station, case number 32 of 2024 before this court.
yes,
There is a specific order.
yes, my lord, what you can,
On that day, I applied my mind
yes, my lord,
and passed this order.
lordship,
So where is that order?
my lord, perhaps, my lord, he has given.
No,
a due-
perhaps. It is
due-
16/8/2025 order.
Yes, my
No
lord.
head or tail.
Lordship, may I, the first page of the report, what? It is a press report has been
This
given.
page.
Yes, first report has been given by,
Ah.
my lord.
Lakhapani PS case number 35 of 2024.
But yes, that perhaps 35, it should not be, because it has to be, my lord, 32 year lordship will
We
find-
cannot read into
Lordship.
that IO written, has written 35
Yes,
and we will read as
Yes.
32. How can it be?
but that cannot be, my lord.
Then
Only then,
very specific order.
yes. Lordship, that has to be.
Instead of going here and there,
My-
you should have straightaway
Yes, straight away.
submitted that
Yeah,
report. Is
report
not
with all the documents.
made over to me.
Report all.
And I've been scratching my head for last 10-15 minutes.
Lordship.
You should have told. We cannot interpret all this unless he says so. From discharge, what can be interpreted?
Lordship.
Get that report.
Lordship.
Here it is said, in connection with Lakhapali 32.
32.
Matter was seized, executive magistrate,
Lordship.
director geology. No documents were found regarding the seized coal. It was found that coal was illegally stored at Lal Pahar.
Lordship.
was auctioned, sold through so and so. The case has already been submitted by Lekapani so and so on so and so. Right? Nothing under of that sort, nothing in support. Where is that? Who is this petitioner?
Not Tehzeeb, my lord.
We wanted to know that the IO submitted a report 10-7
Lords.
and the court applied its mind on 10-7 report
10-7 order.
and passed that order.
Lord.
We wanted to see the legality of that order.
Lords, 10-7. Directly 10-7 order.
Directly 10-7. I was very specific in the order.
Yes. Yes.
Full copy of the report dated 10-7-2025
Yes.
submitted by the IO of Lekapani Police Station case number 32/2024 before this court.
Yes, ma'am. I also must check, well, therefore, I have to also apply my mind for getting what you want to do, ma'am.
Mr.
H. Agarwal.
Agarwal for the petitioner. MP Goswami Land Edition, Public Prosecutor for the respondent number 1 State of Assam are present. Poster Mr. Goswami is to place a full copy of the report dated 10-7-2025 submitted by the IO of Lekapani Police Station case number 32/2024 before this court in reference to the order dated 28-7-2025. The said report has been called for a reason that the Senate court, while passing the order dated 10-7-2025 within bracket Annex 5, referred to the said report and the documents enclosed therewith to dispose of the custody petition number 305/2025 preferred by the petitioner, right? List the case on. Yes, Mr. Goswami.
Yes, madam. Madam,
When? Tell me to. Choose a date of your own.
Lords. Yes. After a
But-
week, after a week.
But if it is auction, Mr. Counsel, there is a provision for appeal. Section 504 BNSS. Once it is auctioned, that auction order has to be appealed, not in criminal petition.
Lordship.
Beware of
after
it.
Lordship's order.
Beware of it.
Yes. The Lordship's order, Lordship may also call for a report that when was the call lifted from the petitioner's
No, we'll
premises?
find out. We'll test the validity of that order only.
After your
We are
Lordship's
not
order, it was-
investigating. We are
No,
not
they have listed
investigating,
the
Mr.
order.
Agarwal, be clear.
Yes, Lordship. It is your Lordship's order, that's why I was indicating, Lordship.
Only we'll see the report on the basis of which that order has been passed, disposing of your petition. If it is auctioned already, we can't help anything. Then there is a provision for appeal. It is an appellate order then.
Lordship.
Fine.
Another.
You have done.
29.
Those type.
That's
Okay,
not
after
for-
10 days.
By Mr. Goswami to place the report dated so and so, along with an up-to-date report.
Lord.
2908.
May,
Get the specific.
yes, may I pray, my lord?
Get a
what I'm saying-
specific
Yes.
report from the IO
Whether-
along with the earlier order.
Yes, this report has been, my lord,
Keep
submitted.
it with you.
Yeah, submitted with my lord, the judicial magistrate first class, my lord.
Ah.
Where- So, my lord, perhaps a record from the that court may also, my lord, because whether if he has submitted there, my lord, whether it
He
will
does
be.
not have any report.
Wait,
He has not said so.
Yes.
He has not said
Yes,
so.
yes, ma'am. Yes, that is what I am thinking, ma'am, whether we can call for
He
also,
thinking perhaps
we can call
might
for.
be, could be. No,
Lordship.
This
Lordship,
court case.
I will.
No, will not go by ifs and buts.
Lordship,
First, he must say that I don't have any duplicate. copy.
yes, ma'am. Lordship,
Will not put the burden on the court.
Lordship.
For hearing, item 31.
By the time it reaches,
My lord,
I
I'll
am
just,
out of my energy.
I'll just cut short it. The question before your lordship,
Yes.
the question before your lordship was that whether railway protection officer is a police officer under the RPM, no, under the CRPC.
No, perhaps.
That is
Perhaps no.
That is no. Second is what? Then the statement which has been during the course of inquiry under section stipulated under section 8 of Railway Properties Unlawful Possession of Railway Properties Act will not hit by section 25 of Evidence Act or not. Any declaration, any statements made, recorded during the course of inquiry by Railway Protection Officer under section 8 of Railway Protection, Unlawful Possession of Railway Properties Act will hit by section 25 or not. And third, my lord, that I will refer when in both these 2 points, this goes against me. Because the law is, my lord, against me. One is regarding Balakrishnan cases, and one is, my lord, because these cases, even discussing in Tufan case has not been overruled. And it has been silent on that, even though the statute, so for the NDPS is very harsh, they have stated, so far 67 is concerned, my lord, they have said that though they are not a police officer, but the statement made under section 10(7) confessional statement will be hit by section 25. If your lordship will distinguish two things, my lord, it will be hard.
Because in Tufan Singh, we have seen
Yes, my lord.
about 6 distinctions
There's 6 distinctions.
by Justice Nariman.
My lord. Now,
So we will not
we'll not discuss
dwell into it.
to go in there. Now, there are 2 cases so far, Durga Prasad, state of UP versus Durga Prasad and Balakrishnan. Now, the second point, so far the Balakrishnan is concerned, it will squarely cover me. Now, whether, my lord, that what Balakrishnan, my lord, if your lord, I'll give you, my lord. Yeah, sir.
No, have it somewhere. Because
I just,
only concern, Mr. Bora, is that I have to rise for 30.
no, I'll short, I'll do it. Within 2 minutes, my lord, I'll finish it off. 2 minutes.
1 minute.
Now, specifically, Balakrishnan's, the question number 2, my lord, which has been formulated, whether a person arrested by an officer of Railway Protection Force under the section 6 of the Act of the illegal commission of an offence under section 3 of the Act is a person accused. What has been a person accused of an offence within the meaning of Article 23, my lord.
What is the act? What is the act?
Yes, my lord. Here, your lordship will say, I have been arrested in a Nahakudia police station, my lord. Not by Railway Police Protection. I was in, my lord, in jail.
No, what is the act?
My lord, act means?
Statute involved here?
Oh, yes, unlawful, my lord, unlawful possession of Railway Properties Act, my lord. Section 8.
The Railway Property Unlawful Possession Act?
Possession Act, my lord. Railway Property Unlawful Possession Act 1966, my lord.
Mr. Bora, please go slow at 4:20 after sitting here since 10:30. It is difficult to
My lord, even for us, even for us,
as swift as you.
No, but for me also, us also, at 4:30, my lord.
Yes, it is not possible for me to go as swift as you.
No, not Only,
Because I have forgotten the factual.
definitely will not, because it's a long time, your lordship had heard. Twice your lordship had heard.
What section?
8, will not, 8.
You said?
And enquiry, will not, 8,
Enquiry.
8. Lordship will find 8,
Let me just say, have a reading.
my lord. When an officer of a force receive an information about the commission of an offense punishable under this act, or where any person is arrested by an officer of the force for an offense punishable under this act, or is forwarded to him, section 7, he shall be proceeded with enquiry with in charge
One,
against the
when
such
an
person.
officer of the force receives information about the commission of an offense punishable under this act. So, there are two parts.
My lord.
When an officer of the force receives information about the commission of an offense punishable under this act. I think this case falls within that,
My lord.
because he receives an
Information, my lord.
that certain
This
materials
has been,
have been recovered or
has
right
been
in
seized.
connection with another
Mahabharata
police
police.
case.
Whereas about 2,208.
Oh, that we are not going into.
Ah.
We are just examining the
My
program.
lord.
How much? 2,000, 3,000? We are not going into that. Second part is not applicable,
No, no.
perhaps. When any person is arrested by an officer of the force,
Well,
that is not there.
no, no.
Or for an offense punishable under this act, and is forwarded to him under section 7. That part is not applicable.
No, no.
First part is applicable.
First one.
He shall proceed to inquire into the charge against such person. Okay. Then subsection 2. Let us read. For this purpose,
The officer of the force may exercise the same power and shall be subject to the same provision as officer in charge of a police station may exercise. Malak Kalisi is subject under the code of criminal procedure when investigation of a cognizable offense.
so inquiry,
My lord.
while conducting inquiry, the officer may exercise the same powers.
Power.
Okay. Provided that
If the officer of the force is of opinion that there is a sufficient evidence or reasonable ground of suspicion against the accused person, he shall either admit him to bail to appear before the magistrate having jurisdiction case, or forward him to the custody of magistrate. That is number 1.
so he can grant him bail or he can forward him
But the magistrate also.
in custody to such magistrate. Okay.
Now, second, my lord.
Ah.
If it appears to the officer of the force that there is no sufficient evidence or reasonable ground of suspicion against the accused person, he shall release the accused person on his executing a board with or without surety, as the officer of the force may direct, to appear if and when so required before the magistrate having jurisdiction, and shall make full report to the particular of the case to the official of the superior.
That did not happen.
It didn't happen.
B did not happen.
Happen.
Okay.
Now, proviso what is been given, though I have been given a power, so I can record the statements which has been laid down in the CRPC. But what the law is this,
I think section 9.
well, as they being not the police officer, they do not have a power to file such it. So they have to go to complain as a 190.
Let us see section 9.
My lord. Power to summon person to give evidence and produce documents. An officer of the force shall have power to summon any person whose attendance is considered necessary either to give evidence or to produce the documents or anything in an inquiry which such officers in making for any purpose of this act. 2. A summons to produce documents or other things may be for the production of the certain specified documents or things, or for production of all documents or things of a certain description in possession or under control of the person summoned. 3. All persons who summon shall be bound to attend either in person by an authorized agent, as such the officers may direct, and the person summoned shall be bound in a state of truth upon any subject respecting which they are examined, or to make statement and produce such documents and other things as may required, provided the exemption under section 132, 133 of the Code of Civil Procedure shall be applicable to the requisition of attendance under this section.
Section 130.
4. Every such inquiry of the aforesaid shall be deemed to be a judicial proceeding within the meaning of section 193 and to the Indian Penal Code. Now, 9 says, 9 is also not applicable to us, Milord. But in my cases, Milord, what has happened, Milord? It's very clear. So that is why the Balakrishnan case, the question number 2, which has been formulated, was squarely covered me, Milord. That it will be hit by Article 23, Milord, of the Constitution. The reason being, Milord, I have been arrested in an Naharkatia. So I was as an accused in an Naharkatia police station. If your lordship kindly see the Balakrishnan judgment, Milord, straightway I have come. That question number 2, kindly see, which has been formulated. This is also a railway protections case.
Right. That day I indicated.
yeah,
Now I have forgotten you.
Yeah.
Forgotten the case.
In fact, your lordship has given a light to me also regarding this judgment. If you kindly see 2, whether, well, lordship kindly see 2.
Which paragraph?
No, first, page 603, the question which has been formulated, Milord. Formulated, that is 2, whether a person arrested by an officer of the Railway Protections Force under section 6 of the Act for alleged commission of an offence under the section 3 of the Act is a person accused of an offence. Or lordship, accused of an offence, Milord. The word which has been accused of an offence within the meaning of Article 23 of the Constitution of India. Now, the relevant paragraph your lordship will find, that is that that is paragraph 60, Milord. Paragraph 60. Question number 2, Milord. 20. The lordship got, Milord? The question number 2, how it has been dealt with. The main contention of Sri Garg is that any confession or incriminating statement recorded by an officer of the force in the course of an inquiry under section 8(1) of 1966 Act cannot be used as an evidence against the appellant in view of the constitutional ban against the compelled testimony imposed by Article 23 of the Constitution. The argument is that as soon as a person is arrested by an officer of the force on a suspicion or a charge committing an offence punishable under 1966 Act, he stands in a character of a person accused of an offence. Now kindly see, that being the case, proceeds of the argument the statement made by such accused person to an officer, RPF, making an inquiry against him can never be said to be a voluntary, being subject to legal compulsion under section 9(3) of the 1966 Act to state the truth upon any subject respecting which he is examined, even if such statement might incriminate him. On this premises, it is maintained that the both conditions necessary for attracting ban on Article 23 of the Constitution exists in the case of such statement. So I skip paragraph 16. These are these judgments are given. As 63 is said, as against this, Mr. Nair, appearing for the respondent states, submit that the conditions necessary for the attracting ban in Article 20 do not exist in the instant case because before filing the complaint in the court, the appellant was not a person of an accused. My lord, kindly see this, of the accused of the offence. It is further urged that the compulsion contemplated by clause 3 of Article 23 means physical or mental compulsion and not compulsion of law to state the truth, that the freedom to tell lies is not within the protection of the clause. It was nowhere alleged that the confessional or incriminating statement in question were extorted by RP officer under physical duress. threat, inducement, or mental torture. It is added that in any case, it is a question of the fact to be established by evidence that any such compulsion was used in obtaining the incriminating statements. Clause 3 of the articles, it has been said, no person accused of any offense shall be compelled to witness against himself. Now, an analysis of this clause shows three things. Firstly, it is a protection is available only the person to an accused of any offense. That is number one, my lord, which is applicable to me in my cases that I have been arrested and I am accused of an offense in a Nahogde police station. That is number one. Secondly, the protection is against the compulsion to be a witness. Thirdly, the protection avails against himself. So statement which has been taken in jail, which I was an accused of an offense, my lord, has been used. So I get a protection under section 23 of the Constitution of India, so far my case is concerned, my lord. It follows that if any kind of ingredients do not exist, this clause 3 will not be attractive. Here is a case, my lord, where he has not been arrested. He was not accused of an offense. That is why it has been discarded, my lord.
Here, all the three has to coexist. First, second, and third. Right. If any of these three ingredients does not exist, then clause 23 article
Well,
will not be attractive. Meaning that the statement can be taken into record. All the three have to be satisfied according to the judgment. Right. Let us assume for a moment you are also an accused of the offense earlier. Now, second part is compulsion.
Compulsion, my lord, kindly see even. You see kindly the evidence or not? Before whom it has been taken? It was in the presence of, my lord, in the presence of jailer, assistant jailer. Assistant jailer was there.
Jailer is not police.
Definitely, but they are the
It
person.
does not fit in
No,
the
no.
description
But
provided
they are the
in
police.
section 25.
My lord, section, my lord, coming aside of the section 25, my lord, where I am in jail. Where they have come? They came to jail. And who is the authority of the jail? Here are the my jailers. And what has happened, my lord, if this is a statement which has been taken, that is in Hindi, translated.
Oh, we are not into preventive
No,
detention. We are not into preventive detention, sir.
No, not preventive decision. But these are the things.
Not NSA. This is simple regular protection.
Protection. So that is why simply these are the things
Now this, compelling situation that you try to read this,
Well,
mention is there.
Yes,
9
Suppose-
judges or 13 or I don't know, 13 is Keshavananda. Or this Kathi Kalo Ogad. Have you read this?
well, I have not read, but
Kathi Kalu. Sheep's para 68.
well,
Para 68 of Balkishan.
the Katikalu, one of the proposition,
No, that there it is the concept of compelling necessity
well,
has been discussed.
yes,
Are you aware of United States America's Miranda rights? Miranda. Have you heard about Miranda right?
no,
Huh?
honestly, I have not heard about it.
Miranda rights. This concept has been brought from that Miranda
Yeah.
rights. And Kathi Kalu Ogad is the first case. Anyway, is Mr. Vora and Biswas available tomorrow?
Yes, well, yeah,
Because we'll make an effort. If possible, you come. We keep it on the board. Both of you reach, then we'll take up. I thought that there will be hearing day. No hearing day. Every day is miscellaneous day.
What will be?
Tomorrow, P. Bora, Senior Counsel, SC Biswas. I'll go through the record. I'll try to pass the order here only.
Only thing, Milan, that is
Second half.
question 23, Milan.
Because three conditions, because
Yes, three conditions.
these are the judgments.
And once,
You
Milan,
require time to understand.
definitely, Milan.
This judgment
Yes,
is
definitely, Milan.
very tough judgment.
In fact, I could not, in fact, so far as Tufan Singh is concerned, paragraph 122, 123, I could not understand also.
Oh, no, very difficult.
Very difficult to understand. That
Have you understood? Find out. Balkishan has been discussed in Tufan Singh. Then Justice Nariman has brought out 6 distinctions.
this distinction, and honestly,
Some I could not understand.
I too mean, with a very confusion every time.
And this Balkishan is also very
But-
very
what about-
complicated judgment.
the complicated judgment, if your lordship kindly see, reading and reading, you will find
Reading one word here or there,
it comes a lot of things
you will go in a different way.
different way.
If you miss one word,
It goes. And secondly, what has happened, in fact, I have also read regarding this Tufan Singh also, some paragraph I could not understand.
no, I read Tufan Singh after this case. I thought that everything is applicable. Tufan Singh is clearly applicable because I read the last part, last paragraph.
Well,
Then I tried to read the Tufan Singh. Then inside there, so many things are there.
yeah,
So many things.
Ultimately,
Tada, Huta, your this
no, if
PM
you,
is there.
then that Magellan's theory is proved. If you read Tufan Singh, you start from first, you reach the end, you find yourself in the same position. You cannot understand anything except that 67, section 67 statement is not
It is
admissible
not
in
admissible.
evidence.
Not admissible.
Other than that,
It is very difficult.
other parts is difficult and inexplicable. For me at least.
Yes.
Okay, we'll write.